this year. So we've got, after this month, I got 11 more months to be able to have this job. It's a privilege. All right, beautiful day. Great to be alive. If it is cold out, let's get to work. Thank you for saying good morning. All right, we'll turn the record on and we'll get started. My friend, the communist, he holds meetings in his RV. We could all use a bit of dose of what that song is about. Good morning, Miss Ellsworth. Can you hear me?
Yes, Your Honor, I can.
All right, very good. We'll be with you in just a moment.
Sounds good.
Your case isn't set until 9:20, but there's no harm in being here early. Attorney
Correction.
Buchnossiger is joining us on his first case, which is Maple Crest Apartments. And he'll be with us in a minute. We'll see whether anybody shows up on that case. We had a 9, we had a 9:10 and a 9:15 that settled. So your case is 9:20. We'll get a head start on that.
Okay. If Meg Bauer
Mr.
joins,
Knopfler.
can I go into a private room with her?
Yes. Someone just joined us as iPhone. Let's see who this is. Good morning. Someone has joined as iPhone. Is that Miss Parker?
Yes.
How do I say your name? Zalea?
Yeah, Zelia.
Zalea. All right, let me spell it.
ZALIYAH.
All right, Miss Parker, good morning to you. You're here and Miss Ellsworth is here, and I'm gonna tell both of you, you're both here on a landlord-tenant case. In each case, your landlord wants you to pay the rent. So these are called a demand for non-payment of rent cases. As such, you have the right to hire an attorney. If you can't afford an attorney, you can see if legal aid would be available to advise you. Or you can seek other legal advice. I just got an email from Meg from Legal Aid, so let me see what she told me. She's got a bit of a delay, so we'll see, but she will be joining us. At any rate, you do have a right to seek legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance and then be prepared to pay the $50 jury demand fee, or you may file a written demand for a jury trial within 5 days of today. You have to pay the $50 fee unless the judge waives it for your inability to pay it. you may be eligible for some emergency financial assistance from the Michigan Department of Health and Human Services, local coordinated entry agency, that's community action agency, housing assessment and resource agency, and our neighborhood, that is Neighborhoods Inc. Or if you're a veteran, you may be eligible for some veterans housing assistance. You do not need a judgment against you to receive help from those places. A copy of the summons and complaint is sufficient. You may be able to reach an agreement outside of the court by going through mediation. If both parties are interested, the court can help set that up. Or you may be able to reach an agreement with the landlord. That means the case would get dismissed through what's called a conditional order of dismissal.
Like you had.
Oh. You're on. All right.
All right. Good morning, everyone. This is Judge Hesslink from the Family Court. On the docket this morning is the matter of Marcinkowski and Huffman. That's file 17-16885-DP. Could I have your name from the county jail, please?
Stanley Huffman.
All right, Mr. Huffman. I do see that Ms. Kraus is here from Otsego County Friend of the Court. Ms. Marcinkowski is here as well. There is a bench warrant for your arrest, which is why you're in jail this morning. The allegation is that you failed to appear on January 23rd of 2026 for a show cause hearing. A bond was set in the amount of $2,450 for your failure to appear on the 23rd. Prior failures to appear include December the 18th, at which time we reduced your $2,300 cash performance bond to a PR bond and required you to pay $500. You also failed to appear on October the 10th of 2025, August 22nd of 2025, and May 23rd of 2025. I'm going to hear from Ms. Kraus if there's any update. I'll hear from Ms. Marcinkowski, and then Mr. Huffman, I'll hear from you as well. So Ms. Kraus, any update as to what I've said so far?
No, Your Honor. At the January 23rd hearing, we did indicate that the defendant did make a credit card payment on January 13th, but it was not, it wasn't the amount that was requested, and it wasn't done by the date requested from the prior support enforcement order.
How much did he pay on the 13th?
He paid $450, and then he did make an additional credit card payment and spoke with the supervisor of Friend of the Court at, I think it was like 1:13 the day of the hearing. He indicated that he left me a message, and I have not followed up with him. Indeed, he did, but he left me a voicemail while I was in court with you at approximately 10 something that morning. So I haven't had any good contact with him in regards to that. And additionally, like you had indicated, there had been 3 previous bench warrants, all reduced to PR with conditions that he's either failed to comply with those conditions and then ultimately failed to appear, and another bench warrant was issued. His support obligation is $536. That sum is composed of $378 for current support, $158 for overdue support, and his arrears balance is $9,377.44.
All right. Ms. Marcinkowski, have you been receiving any payments recently?
That payment of the $400 payment, I received that more towards the 23rd, but not often.
All right. Is there anything else that you want me to be aware of right now?
I don't make a lot of money. And I am paying for Zane to go to daycare. And I made up a total of it's $680 a month for daycare. So I'm paying $8,160 a year for him. Mind you, I have 3 kids, so I'm paying $510 a week for daycare. Stanley has not seen Zane. He does not see him. He does not take care of
You
him.
don't
And-
let me.
Mr.
Sorry.
Huffman,
Sorry.
you're gonna be,
Sorry.
yeah, you don't get to shout in court.
Sorry.
You have a chance to say what you need to say, but not right now. All right, Ms. Marcinkowski, today is the day for child support, not necessarily for parenting time. Okay, so any additional information on child support that you have?
Nope.
All right. Have you given the information about your daycare costs to the friend of the court recently?
No.
All right. If you believe that that would be something that needs to be added in and decided about concerning child support, then you need to submit that information to the friend of the court with a request that they change their amount that's due. And then the referee can have a hearing on that and make a decision about whether that should be added or not. So please talk with Ms. Kraus or make that motion on your own, whichever you prefer to do. All right, Mr. Huffman, what do you have to say for yourself?
I try to get a hold of her to see Zane. She says no or ignores me
Okay,
or does that face that's hold on. Just let me speak, please. I need to get this out because this has been going on for years. I'm paying so much money.
Today is not about parenting time.
I know I'm not talking about parenting, but I'm saying this leads up to my money situation.
All right, go ahead. Go ahead.
It's the faces that she's even making now is already showing that she just doesn't care about my side. So
Sir, I'm not gonna listen to either side. Cut down.
I didn't think I was
if you have
going
something
off
to
of-
say about child support, go right ahead, but I'm not gonna listen to you
I know that.
get bad on her. Go
No,
ahead.
it's not about that. I'm trying to lead up to the money.
Then
If
get
I
there.
can't see him, why am I paying so much if I'm not allowed to see him when I'm trying to pay. I am. I already paid that $450 plus the $30. I don't mean to miss court. It's not like I avoid you guys. I turned myself in last time. I'm not trying to avoid this stuff. I'm trying to make the payments. It's just really hard when I'm literally on my own. I'm doing this by myself, not raising anybody is what I'm saying, but my whole life has been really on my own. It's not that easy, obviously. I know it's an adult life and you have to do what you have to do, but it's not easy. I don't have parents to fall back on. I don't have a roof to fall back on. I'm getting evicted out of that place and I can barely afford to pay that right now. And I do have a training job at KFC today at 12. And I'm trying to make it back. All the mistakes I made before was just because I was a dumb idiot, really, if I can just say it like plainly. I made a lot of dumb mistakes and now I'm paying for it to try and catch back up. And it's hard. And I do feel bad that I haven't paid for Zane. And I feel bad that I haven't been there for him. It's not something I want. I never wanted that for my kids. And I'm sorry, Danny.
All right, thank you, Mr. Huffman. Let me talk to you for a minute about parenting time and child support, Mr. Huffman. I understand as a dad that parenting time and child support go together in your mind. However, under what the law says, those two things are not connected as strongly as you think that they are. There is an obligation to pay child support even if you do not have parenting time. That's what the law says. It's not something that I'm making up. It's not something that the friend of the court is making up. That is what the law says, period. So even if you have zero parenting time, you are responsible for child support because the child, and again, it's not the child's fault that the child takes money to live. The child didn't have any say in coming into being. The two of you did that, okay? Mom and dad. So the child has to be taken care of. And child support is one way of divvying up that responsibility. So whether or not you have parenting time is a separate question than if you have child support. It would be good if the two of you could work things out where everything could be together, but you haven't been able to do that. It would be good if you could have more parenting time, but it hasn't happened yet. But the child support continues, and that's for the child. It's not for the benefit of either parent. It's for the child to live on and grow appropriately, okay? I'm not going to tell you that this is a perfect system. It's hard. Life is hard. I'll grant you that. And I'm not going to tell you that what you told me is any different than a lot of other people that I hear from. Life is not easy for lots of people. That doesn't change your responsibility because the child has certain costs just to live. So I'm not mad at you. I just wanted you to be aware of the differences there as to what the law says. And that's why we treat you like you got treated today by being brought to the jail by not making your child support payments, even though you're not seeing your child. Does that make sense to you?
Yes, Your Honor. But I know I'm not making the payment, or I wasn't making the payments, but I am making the payments now, and I am making an official effort to make those payments.
Well, let's talk about that. So, all right, let's go there. You were ordered on December the 18th to make a $500 payment by January the 2nd. By your own admissions, you're short and late. Okay, not the end of the world, but still not making the payments when you should have made it. And in addition to that,
can I say something on that?
In a minute, yes. We got to kind of do things in order. So let me get done and then I'll let you go. Okay, no, you're all right. You're all right. So you were late on that payment and you haven't been making your normal monthly payments. That $500 payment was kind of like a makeup, right? It was a makeup for ones that you haven't made in the past. And then you were supposed to start making your regular $536 a month payments. You understand?
Yeah. Yes,
all
Your
right,
Honor.
go ahead. Tell me what it is that you want me to hear.
The only reason why I didn't make the payment on January 2nd, I had the money, but I had some things come up. Obviously, adult life, my discount tire. I tried to get 2 new tires because the front blew up and the one side had a hump in it. I was trying to wait as long as I could and it wasn't happening. And they had to replace the back. Legally, technically, they have to replace the back before they replace the front. So I had to pay for all 4 tires. And I'm trying to I'm $3,000 behind in rent right now. I'm trying to catch up. And I just got tickets for the no insurance, no tags. Like, I'm trying to catch up. I'm trying not to give up. I'm really not. Especially because I miss my kid, our kid. And I know it doesn't seem like that with the way I've gone about it, but I was kind of reckless and immature. Not even kind of, I was. I'm really hoping that you don't keep me in jail. I'm trying to make these payments. I'm trying to come out of the hole. The hole I dug. You reap what you sow, and I'm trying to unsew a lot of stitches.
Mr. Huffman, I believe what you're telling me. Just the fact that you're standing there telling me that the way that you're telling it to me makes me believe that you are making a better effort than you have in the past. So I'm not disputing anything with you there. My job as a judge is to try to figure out if people are lying to me, number one. And then number two, what to do about the requirements of what the law says. what you've told me about the reason that you didn't make the payment is the same as probably 98% of the people that come before me. I don't believe that you got 500 extra bucks in your bank account and you're not spending it on your kid. I don't believe that. And I know that's true. So I assume every time you come in front of me that you had bills that you needed to pay. Like you said, the tires of your truck blew up, the rent's due, the medical payment that you needed to do. I assume that all of those things are true, but that doesn't change the fact that your child has to eat and that there's heat and lights and medical payments and whatever else that goes into putting a child into the world in a way that the child can thrive and succeed. So I don't doubt what you're telling me. I'm not calling you a liar. I believe everything that you're telling me. But those are the normal facts of life. Those are the things that happen to everybody in dealing with child support. It's never easy. It's that I can't put it any plainer. That is how life works. So I'm not mad at you, but I got to figure out now, where do we go with this normal life thing, bills piling up, and how do I get you on the straight and narrow and keep you there so that the payments can be made for all of your bills? Go ahead.
I do have my training for KFC at 12 today. If I get let out, obviously, but I'm probably going to lose that job if I don't.
I hear what you're saying to me. So, Ms. Kraus, when was the last time Mr. Huffman's child support was reviewed?
It appears that it was done in September of 2024.
So relatively recently, a year and a half ago or so, a little over a year. All right. So, Mr. Huffman, you're not entitled to have an automatic review. That comes every 3 years, an automatic review to make sure that your income and the child support recommendation are the same, are consistent. I don't know, because I wasn't the judge in 2024, what your status was then. Is it significantly different now than it was in 2024 in September?
Are you asking like my situation wise?
Your work and income situation.
Oh, it's been on since last year, September. I haven't been able to find a job really since.
All right. In
2 years ago.
In September of 2024. So it would have been more than a year ago. So I assume back then you were working at a minimum wage job, basically.
Yeah. No, I was making decent money for a little bit of time. Not really decent money, but enough to somewhat pay rent, I guess.
All right. Well,
but it wasn't enough to catch up on all my other bills.
Your Honor.
Yes.
The last calculation, I was able to pull up that information. It was based on $11 an hour at full time, which is less than what minimum wage is currently for the state of Michigan.
All right. So it sounds to me like you're at the appropriate level. Even if you were to get a job at KFC, they may be paying you a little bit more than minimum wage, but not a whole lot. And as Ms. Kraus has already indicated, that's where your current income level is for child support purposes, $11 an hour.
Yeah, I can say that last year, 2025, my tax return, I had one job all year and all the rest of them were side jobs. And I've been trying to catch up. Like, I don't want to be a lazy person. I hate being lazy. I hate sitting at home. I want to work. But I burnt a lot of bridges, dumb and young.
When we're dealing with child support issues, the child support formula assumes and presumes that you're working almost full-time at least minimum wage. So even if you aren't actually doing that, we're required to use that amount of money in the formula. So I can't reduce it any lower than that. So basically what Ms. Kraus is telling me, and I'm telling you, is we're at the lowest level that it's ever going to be. Okay?
Yes, Your
Understand?
Honor.
All right,
Yes.
so I can't.
I don't want to ask for it to be lower, to be honest. I want to be able to catch up.
All right, so I need to get you out and get you working, and I need to get you.
Good morning, Miss Reed. Can you hear me?
I sure can. Good morning. Good to see you.
Thank you. You too. Ms. Ellsworth, would you come back, please? All right. I have advised Miss Ellsworth of her rights as a tenant. She was here early, which I appreciate. And so we went through that. Attorney Sarah Reed is here on the Palitz Law Firm on behalf of this park. This was previously known as Meadow Lane Village. For many years, they had Mr. LeBray as their attorney. Now they're known as Three Rivers Village. And this is Three Rivers Village versus Brianna Ellsworth. The matter is a ongoing saga of demand for rent for lot only, which is always a little more difficult. Ms. Reed, what's the circumstance here? What's the alleged arrearage?
Thank you, Your Honor. Exclusive of court costs, I showed 2364.56.
And it is lot only?
Correct.
Is there a late fee in there?
There are late fees. There's utilities as far as water and sewer. I think those are the only utilities that are charged.
And so we're going to need to break that down. Some of the attorneys do a judgment form, which tells me how it breaks down. Ms. Ellsworth needs to know exactly what she owes. These lot only cases are troublesome. You and I have discussed it. Some courts don't allow it. It isn't even clear whether the law allows it. But Ms. Ellsworth, you own your own trailer?
I do not, Your Honor. My cousin does. My
right,
cousin
but-
Ashley Rosner does, which she is on the lease with us.
All right, what's her name?
Ashley Rosner.
Ashley Rosner,
Yes, Your Honor.
and she is on the lease?
They had her get on the lease because she owns the trailer. Yes.
Does she live there?
No, Your Honor.
All right. Who does live there?
It is me and my wife and my child that are on the lease. Well, yeah.
All right, so the way this was filed, Brianna Ellsworth or all other occupants. All right, rent is alleged to be $378 per month. Miss Reed, could you tell me how much is rent, how much is utilities, and how much is late fees?
Yes. So let me do exceptionally quick math here. So the rent itself is the $378 times 3 months. No payments have been made since October. So the rent itself is $1,134.
So that's November, December, and January, but not yet February.
Correct.
Okay. And then how much are utilities?
Well, I've got to go back. I apologize, Your Honor. It's been a long time since I've been in front of you and I didn't put together.
Well,
a
I'm
breakdown.
amazed that everybody doesn't ask this question. We meet, you appear in a lot of different jurisdictions, but the homes are difficult because there's often a utility in there. There's some other fees, a hookup fee or a payment fee or something. And, but I'm surprised that every judge doesn't ask, where did this number come from? But, anyway, so rent is $378 per month times 3 months, soon to be 4 months. And then the utilities are, how much is the late fee?
The late fees are $85 per month times 3 months.
All right, I don't allow 85 per month. I've gone up to 50. There's supposed to be some rational connection between an actual loss and the late fees. The law is very unclear on late fees. I just had one where the lease was $1 a day, which isn't necessarily connected to anything, but I'll allow that. But $85 a month for lot rent, there's no actual connection to it. So anyway, what's currently alleged is 85 per month times 3. And then how much are utilities?
They vary each month. If I can.
Yes.
Do my best.
City water can be expensive, but how much of this is utilities?
If you want to give me 45 seconds, I can come up with that.
378 times 3 is 1134. All right, so I'm gonna make 50 times 3, which is 150, is 1284. I better put the other 105 plus 105. So 2,364.56. I didn't write that number down. 85 times 3. Oops. Plus 378 times 3. This is a lot harder than it needs to be.
My apologies, Your Honor. Sometimes if there's a lot of different fees, I'll do a spreadsheet with all the different charges, and I did do it for this morning's hearing.
$255. So if we subtract 2,364.56 minus 1,389, you're contending that $975.56 are utilities.
Well, I guess it wasn't as bad as I thought. I came within $30. So what I'm showing is the water and sewer for the 3 months is $428.43. And I'm just going to do the numbers that will get to the number that I have, and then I know that you're going to waive the late fees, but I'm showing the late fees at $255, which is the 85 times 3, and I understand you're going to reduce that, but I'm just trying to do the math first. And then,
but that doesn't add up to that number.
No, I understand. And then I've got $11.34 for rent, $30 for 3 months of pet rent, the $10 a month.
Pet fee, okay.
Yeah. And then there was a beginning balance at the beginning of September, November of $186.66. I don't know what that is made of. My ledger doesn't go back earlier than October. So I just had that carryover. I'm not sure if that's when the park was bought. And then there was a repayment plan that Ms. Ellsworth had gotten into with with our client at $100 a month. So there's 3 $100 payments of that repayment plan. And that brings me to 2334. So I'm within about
2334 or 2364?
I come up with 2334. So my quick math, I'm about $30 off from.
All right, well, Miss Ellsworth, I'm confused, so I'm sure you're confused. There's a bunch
By
of
far,
stuff
Your
in
Honor.
here which isn't readily apparent. There's rent, there's utilities, there's excessive late fees, there's pet rent, there's a part of a repayment plan. So it's not clear. You indicated you wish to talk to legal aid. She'll be here, and I can leave you here with us while we wait for Ms. Bauer to come. At either rate, we have to continue this matter for 7 days at least. So I'm going to continue this.
I do have a question, Your Honor. I was
Yes,
brought to court back in October for this place.
yes.
And supposedly if I owed that rearage, why was that not added into court back in October?
I'm not sure I understand your question.
So she just stated that I had a rearage of $1,000 and something dollars. I was taken to court
Didn't say
back in
that.
October, and I paid a total of $2,186.66. Why was that not added into the rearage? Why is that
I don't
rearage
know
not
the answer
added
to
into
that.
that?
So
Just to be
let's
clear,
take
Your
a
Honor,
look
I
at
didn't say she had $1,000.
what?
And she said, said that there was a $1,100 rearage. That's not what I said. I just wanted to clarify that.
186.66 is what she said. Anyway, we got problems here figuring out an actual number.
My paper here says 1,368.44 of a delinquency balance.
All right, well, let me ask the fundamental question. Why haven't you paid your rent since October?
Your Honor, honestly, I am currently fighting disability. I know there is no excuse on why rent is not paid, so I do take that fault on my behalf. I am also waiting for my school money to pay this rearage. That way
You're
that
asking
is
for
taken.
who to pay it?
I'm waiting for my school money.
Oh, school money.
Yes, Your Honor.
Well, people do that. They steal their educational money. BRIANNA.
Your Honor, if it's helpful for Ms. Ellsworth, there was a judgment that was entered in October for $2,186.66, and I'm only showing a $2,000 payment. So that's what led us to a beginning balance of $186.66. It was the amount left over
Yes.
from the judgment.
Yes,
All right.
that I do have.
So we do this in October. You pay much of it, but not all of it, and then you don't pay any rent since October. Here's the deal. They're moving to evict this trailer off the lot. The way they filed it, they didn't file it as a just cause termination. They filed it as a non-payment of rent. So they work out a deal. You do a repayment agreement. You pay some, then you don't pay anything on the repayment agreement. You haven't paid October, November, or November, December, or January's rent. And we're about to add February into everything, which is going to increase this. What they're
Which
asking
February will
you to
be paid
do.
next week.
Okay, good. The problem is that I'm clear about the number. Maybe we could figure it out more as we get here. But if it's gonna be paid, that'll be great. That'll solve it. This trailer's probably been there for 40 years or more. Probably can't just be removed from the lot, but that's what they've asked me to do. I'm gonna continue this to next Friday, February the 6th at 1:50. Does that work for you, Miss Reed?
It doesn't. Is that 150?
Yes, 150.
Yes, thank you. Just wanted to clarify.
Now, Miss Ellsworth, you can stay with me and wait for Meg Bauer to join us. Or you can simply call and talk to them. Or
Do you
if
have a
you're gonna
number for
pay-
Meg?
Yes, it's in the pleadings that we sent to you. I don't have it off the top of my head. Do you see it?
Mhm.
I've got her number, Brianna, if you want to write it down.
Yes, please.
Are you ready?
Yes.
It's 269-366-3388.
Thank you.
You're welcome. And let her know, my name. I work with Meg a lot, so just let her know
Okay.
to reach me after you talk with her.
I do have a
All right.
question for you, Sarah, as well. They're trying to charge me $100 a month through September of 2026 of a payoff of $1,368.44 delinquency balance. You know what that is?
I
Yeah,
don't, but
apparently
I
they
will-
worked out some agreement with you to catch up on your arrearage. And they're claiming you didn't hold up your end of the deal.
No, because we haven't made no agreement since October. None at all. When I spoke
I'll
to
ask about
Bonnie,
that so I
she's
can
trying to
talk to
say
her.
this was from
All right,
beforehand.
we'll try to sort. All right, well, you're pretty belligerent for somebody that hasn't paid your rent in 5 months. So they're asking you to either pay the rent or move out, but I do agree with you. You need to know the total of what it is they're claiming that you owe and what it's for. And I'm not clear on it, and neither are you. But you're contending that when we get the number, you'll have the ability to pay it?
Yes, Your Honor.
All right, well, that's good news.
I just got to know an exact amount so I do know what I'm paying.
I don't blame you. All right, you can either choose to wait or just call Ms. Bauer. I think
I
she's
will give her
caught
a
in.
call.
All right, then I will see you next Friday at 1:50 and we'll work further on these numbers.
Okay. All right,
Sounds
thank you very
All
much.
right,
Anna.
Thank you.
All right, maybe I think that one's gonna work out. I don't know why that's so hard. I ask how much is due and what is it? And people often struggle giving me that answer. Good morning, Mr. Dutka.
Good morning, Your Honor.
All right, we have Mr. Simran Singh, and we're looking for Carrie Harris. Are you Carrie Harris? Could you unmute your microphone? Very good.
Is it-
Are you Carrie
can you-
Harris?
I am.
All right, let me give you a proper name. Good morning, Mr. Dutka.
Good morning again, Your Honor.
Your tenant, Rebecca Weber, is not here yet. So we'll address this one. We got a little behind with our last case. This is Simran Singh versus Carrie Harris. This is filed as a demand for termination of tenancy. I checked the wrong box. He wants you to move out, Ms. Harris. You're a tenant in that type of proceeding, which is called a termination of tenancy proceeding. As such a tenant or defendant in a landlord-tenant case, you have a right to hire a lawyer. If you cannot pay for one, a legal aid attorney may be available to assist you, or you can seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. If the action is for non-payment of rent, the Michigan Department of Health and Human Services local coordinated entry agency, which is community action agency, a housing assessment and resource agency, which is Neighborhoods Inc., or other program. If you're a veteran, you may be eligible for some programming. If this was for non-payment of rent, but they're not asking you to pay the rent, they're asking you to move. So there's no sense asking for financial assistance because it isn't that type of case. However, you do have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance or file the demand in writing within 5 days of today's date and pay the $50 jury demand fee unless the judge waives it for your inability to pay it. You may be able to reach an agreement with the landlord through mediation. If both parties are interested, the court can help set it up. Or you may be able to reach an agreement with the landlord that would result in the conditional order of dismissal. And if that is the case, we could assist with the preparation of that. Mr. Singh, am I correct? At this point, you're simply asking for your property back?
Yes, Your Honor.
Ms. Harris, what's your position?
Well, I have some questions. I mean, I've been up to date. I'm not that I was a little bit behind, but I'm not behind. Our numbers don't add up. I have receipts that they didn't have, and it's just a bunch of paperwork that actually should be gone through. I got a notice to quit. I'm not really familiar with this kind of stuff, but
Okay.
and it says that I must move by 12/1 of 2025. I do believe that you got a copy of it and with that packet of
Yes, you got a
papers.
notice to quit on October 31st, telling you to move by December
Yes.
1st.
And
Well, you
he
didn't
and
move.
he and well,
So
and
he filed this
he was
action to terminate your tenancy.
okay. Well, because was he supposed to collect rent after that time?
All right, so he collected rent after October 31st?
Yes.
All right,
I
tell
have
me about
receipts.
that. When did you last pay the rent?
Yes, Your
I
Honor, I do have them on file. She paid one on
All
January
right, just a
7th.
minute. I didn't ask you that. I'm
Oh,
talking to her.
I have
Give you a
right here.
chance to. All right, when do you say you last paid rent?
I paid rent on 1/3 and 1/6 in January.
All right,
And on 1/3, it says I paid $500, and on 1/6, another $400. And that's for January.
all right, Mr. Singh, you were gonna tell me, what did she pay?
Yes, Your Honor, she's absolutely right. She paid me on January 7th. She paid me $300 through Chime. And then on January 10th, she paid me $250. And in December, she just paid me $250, which I already have the receipts. I already have like text messages. Whenever she pay us, I send her a text confirming that I did receive the amount. And then I have receipts also. And then I wrote down everything on a paper, so I documented it. And then, yeah, so she did
All
pay.
right. Well, you need a lawyer.
Okay.
Once you file an action to terminate the tenancy,
Okay,
you
sir.
can't accept any money.
Okay.
If you file it as a demand for non-payment of rent, you can take money, but you've just submarined
Okay.
your own case. You can't file a termination of tenancy and then accept rent.
Okay, Your Honor.
There's a case, it's called Park Forest, which explains that. That's why I think you could use a lawyer to help you with this. If you're gonna be in the landlord-tenant business, you should know what the rules are. So
Sure.
I'm gonna dismiss this case. You're gonna have to
Okay.
start over again.
Sure.
You've accepted payment of rent after filing of a termination of tenancy.
Your Honor, she had a past due which she was paying. She had water bills. I already wrote it down. That's what she was paying.
In your
Well, you accepted payment.
Yep, I did accept payment,
So
but
if
she
you
had
want to do a
payment from the past.
non-payment of rent case where she could pay the rent and stay, you
Okay.
could do that. In that case, you can accept rent. Let me make sure I got my facts straight here.
I think I
me
filed
look
for that too, Your Honor.
You did the notice to quit correctly,
Yep,
but
yep.
yeah, it's a termination of tenancy. You can't take money after you file a termination of tenancy.
Okay, Your Honor.
So Ms. Harris, maybe you and Mr. Singh can agree how much you owe and try to get caught up on the rent. But I'm dismissing the case.
Yeah, I have no problems with her until unless she pay on time and then everything is good.
All right, well, how much do you believe she owes you?
She owes me $360 in rent, and then in water bill, she owe me just $506.
Your Honor, how am I supposed to pay a water bill when I don't get sent a copy of the water bill? Because it's not on my electric bill.
Well,
They
I'm
get the
not-
water bill.
I'm not gonna make any decision on that.
Okay.
You
All right,
guys can
thank you.
talk about it.
All right.
But Mr. Singh, you could use some legal help. Didn't Mr. Rogmus help you in the past?
No, sir.
Well, there's a certain set of rules and the landlords are held to a strict standard under the Landlord-Tenant Relationship Act, Truth in Renting Act, and a bunch of other pieces of legislation that apply to this. And then there's case law, as I mentioned, People versus Park Forest. So if all you want to do is collect rent, you can talk to her and she could pay the rent and stay there. Ms. Harris, if
Okay.
he'd gotten what he'd asked for, I would have had to adjourn this matter for a week. And then I would have given you 10 days from that day to move out. So you would have had to move out by February 16th. And people often tell me I would move if I had somewhere to move to. How much is the rent
It's $1,000
per month?
Well, yes, plus I pay all my utilities.
All right. I don't know the answer to that. I'm willing to put the two of you in a breakout room so you can talk to each other, but this case is dismissed.
Thank you,
Right,
sir.
Thank
I'll
you,
do an
Your
order.
Honor.
You can start over again, or you can work out some agreement where she pays the rent and gets to stay there. But the
We'll do that.
termination of tenants. I'm sorry, sir, go ahead.
No, I said, you good, sir. Yep. Go ahead, sir.
Do you want to talk to each other while you're both here or just work that out
Yes.
later?
Yes, Your Honor, I can talk to her right now.
All right, you guys can discuss how much you think is owed but this case is dismissed because you accepted payment after filing a termination of tenancy.
Thank you, Your Honor.
Yes.
All right, I'll do an order. Good morning, Ms. Bauer.
Good morning, Judge. My apologies again for missing the first part of your docket
Well,
this
thanks
morning.
for the email to give me the heads up. We did have a client that requested some assistance. She was gonna wait for you, but she's gonna call you. Her name is Brianna Ellsworth. It's the Three Rivers Village Mobile Home Park. And Sarah Reed is the attorney on the other side. And so you may be hearing about that one. It's
Okay, thank you.
another lot only with unclear late fees, unclear utilities, unclear repayment from the past. Miss Reed was a little taken aback. It's like, why doesn't everybody ask these questions? You know, where did you come up with this number? It doesn't seem like that's that hard, but you appear in a lot of different jurisdictions and so does she, but my lawyers know what I'm asking for. Our pro per landlord, Terry Richmond, who gives me a to the penny breakdown, and sometimes it's, I don't know, I guess maybe it's my own fault. I haven't, she said, well, you trained me, because I haven't trained everybody else. I trained Mr. Dutka, so he's all right.
I've been actually thinking about how to write a bar review article about that. I actually thought about talking to you about doing one together, and then I thought maybe we'd have to bring in someone from plaintiff side too. But it is something I see inconsistently, and there's a lot of things where the
Well, there's a
pleading-
lot of things. There's late fees.
Yeah.
The whole issue of lot only versus just cause termination. And as you know, we spent a lot of time in the District Judges Association trying to parse that question out and came to the conclusion that there's no good answer to it. But late fees, other related fees, as you know, the attorneys that just give me, and then we end up chasing our tails trying to run the number down as opposed to the attorneys that just give me the financial breakdown and I can see it in a glance, but that's sometimes how it goes. All right, Mr. Dutka is here and his matter is set for 9:40, no, 9:51. Good morning, Mr. Dutka.
Hello again, Your Honor.
And my fourth time to tell you hello this morning.
Could be.
Good morning, Mr. Felt.
Good morning, Your Honor.
Good morning, Court Security. I'm looking for Rebecca Weber. All right, thank you. Bye.
Pleasure to see both, Mr. Dutka, Your Honor.
All right. Well, tonight, Michigan State plays Michigan.
I'm up and ready.
All right. Yes?
The defendant, for Mr. Ducka's hearings,
Oh, yes.
they're waiting for you to accept them, and
I don't see her in the waiting list, in the waiting room. Tell her to try again. I don't see her. So Rebecca Weber is in the background?
yes.
All right. All right. Either have them try again or get their email and I will send her an invite that she can just click on to.
Okay, will do.
All right. Mr. Dutka, your client is in the background. Good morning, Mr. Baxter.
Good morning, Your Honor.
We'll be with you in a couple minutes here. We're a little bit late.
Okay, no
Running
problem.
a little behind, but not bad.
I'm early, Your Honor.
Yes, you've got the 10 o'clocks. In fact, I'm gonna take leave for just a minute and grab those 10 o'clock files, so everybody stay put. You guys asked me for a search warrant, you just nothing to say goodbye. Miss Harris, what case are you here on? Oh, she's gone. Mr. Felt's client is Richard DeWitt. And that matter is set for 9:50. So let's take up Mr. Felt's case while we wait for Miss Weber to log in. Hello, Deputy Broker. This is me again. I'm looking for a Richard DeWitt. All right, thank you. Bye. All right, the alleged Mr. J. Felt is here on behalf of his client, Julie DeWitt. This is a termination of tenancy for a tenant that's in a storage building on the property at issue and isn't supposed to be there. Defendant was personally served for this hearing on January 8th. Mr. Felt, as far as you know, is the defendant still in that storage building?
Yes, he is, and frankly, it's out of character for him to appear today, Your Honor.
Yes?
Mr. DeWitt has never been to the hospital. Remember?
Oh, yes, yes.
And then Elaine's on the phone with that lady getting her information.
Mr. DeWitt is in the hospital. And got a call from Julie Harden. So he's in Three Rivers Hospital, probably because of the cold. So I'm gonna adjourn this matter until 2 o'clock I got such a short memory. She told me this an hour ago. February 6th at 2 o'clock. Does that work for you, Mr. Felt?
I can make that fit, Your Honor. Tell me again, February 6th?
Yes, next Friday.
Oh, sure. Let me look at that. Yeah, I get it. Adjourn 1 week to 2 o'clock.
Yes, they called early this morning indicating he'd been admitted to the hospital and he's there now and unable to attend.
That's kind of that's kind of his MO, Judge.
Well, all right, he's in the hospital and I can't default him really.
Oh,
so
cool.
We'll do it next week and but he can't, as the song says, you don't have to go home, but you can't stay here.
Well,
Closing time.
I've been told that a few times.
She has no Wi-Fi, so she can't Zoom in.
All right.
She has a phone number.
All right. All right, Mr. Felt, that's the best we could do
That's
tonight. I
wonderful.
hope your team wins tonight.
Thank you, Judge. I'll see you next week at 2 o'clock. Thank you, Your Honor.
All right, Mr. Feld, I'll see you next week, and that's the best we can do at this time.
That's good. Thank you, Judge.
Thank you. All right. I've got Wendy Davis. Mr. Baxter, which case are you here on?
Wendy Davis, Your Honor.
All right, well, we'll take care of her in a minute, but first we've got to dial up Mr. Dutka's landlord-tenant client.
Hello?
Good morning. Is this Rebecca Weber?
Yes, it is. Is this Judge Middleton?
Yes, it is. Good morning, Miss Weber.
I am here and ready to go.
All right, we'll make the best of it. We're doing this by telephone, which is not ideal, but Mr. Dutka is here, and this is title of this case is Ambassador for Christ versus Weber. Are you outside?
No,
All right.
but I live in the basement.
All right. Yeah, it says you have one room.
Yes.
Well, they want you to move out. They filed what's called a termination of tenancy action, and they want you to move. As such, you have certain rights as a tenant, and I need to go through these with you.
Okay.
We're getting a lot of static or background, either from your breathing or. All right.
No.
All right. You have the right to hire an attorney. If you cannot pay for one, a legal aid attorney may be available to assist you. Meg Bauer from Legal Aid is here with us on the feed. You have a right to have the case heard here in St. Joseph County where the property is located.
Yes.
And that's a no-brainer. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance or make. Becky, you're breathing right into that microphone and it's really causing a lot of distortion.
I'm sorry. I'll hold it away from.
All right. If you want a jury trial, you have to tell the court here at this first court appearance or make the demand in writing within 5 days and be prepared to pay the $50 jury demand fee unless you're unable to pay it, the judge excuses it. You may be able to reach an agreement with the landlord outside of court, but by going through mediation. If both parties are interested, the court can help set that up. Or you may reach an agreement with the landlord, which would result in a conditional order of dismissal. Mr. Dutka, the Ambassadors for Christ Church owns this house on South Main Street, and they sort of try to provide housing for people that are in need of housing. She has a month-to-month tenancy, and at this point, they're asking her to move out.
That is correct, Your Honor.
Ms. Weber, what's your position?
It's, it's her house, it's her, she's my landlord, whatever she wants,
Well, the first thing we have to do is adjourn the matter 7 days.
Okay. Well, I guess maybe I should talk to Carolyn then.
All right, well, that takes us to February the 6th. And then you would get 10 days from that day to move out or be subject to being evicted.
Mm-hmm.
So essentially, that would give you until February the 16th to move. Do you think you could do that?
Yeah.
Have you got someplace to go?
No.
Yes, that's why you're there. Well, first of all, we're going to adjourn this till next Friday at 2:10. Does that work for you?
Next Friday.
February the 6th.
Okay.
Does that work for you, Mr. Dutka?
Yeah, it can. I would have to try to rearrange an appointment, but maybe
Well, I
I
can
do that.
continue it to Monday the 9th if you'd rather I did that.
Let's see what I got going there. That's better, actually. Much
All
better.
right, well, let's take a look. That gives her a couple extra days.
Okay, February 9th.
Yeah, let's look at the calendar and see what time works.
Okay.
V9. 2:10 on Monday, February 9th.
That's fine, Your Honor.
All right. All right, Ms. Weber. If they get what they asked for, they would get 10 days from that day, which would be February 19th for you to move. They're not asking you to pay rent. They're simply asking you to move. And I think there are 6 people living in this house, or I don't know. You just have the basement.
There's me and another girl.
All right.
Plus the squatter.
All right. And where's the squatter?
Standing here.
Oh, is the squatter in your room?
Yes.
Oh, all right.
The squatter's leaving today.
All right. That may be why they want you to move. It's you and all other occupants. Who's the squatter?
Megan Reed.
Okay. All right. If she gets out, maybe they'll have a different view of things. You can. Who's managing this, Miss McNary?
Pardon me?
Who's managing the place?
Yes, Carolyn.
All right. Well, you can discuss that with her, but we're going to continue this till Monday the 9th.
Okay, and then after Monday the 9th, it's 10 days.
10 days from that day.
What would be the date?
February 19th.
Okay. I didn't know if that was a weekend or what.
That's a Thursday. As a practical matter, they probably wouldn't get rid of eviction until Monday the 23rd, but the actual date is Thursday the 19th.
Okay.
All right, Miss Weber, I would rather not do this by telephone. If you can either log in or come over to the courthouse, but we'll address this further next 10 days from now on February 9th at 2:10.
Yes,
All right, thank you.
that would be wonderful.
Okay,
Thank you.
all right, goodbye.
Thank you, Your Honor.
Bye. All right. I went to high school with Miss Weber a long time ago. And she's just making her way through life. Okay, thank you, Mr. Dutka. I'll see you on the
You bet.
9th.
You bet.
And bear with me. I'm gonna do a couple general civil matters and we'll come back to landlord tenant. All right, it is 10:08, which makes us 8 minutes behind schedule, but all things considered, that's not too bad. The matter we're going to address right now is Velocity Investments versus Wendy Davis. Ms. Davis, can you hear me?
Yes, I can, Your Honor.
All right. This is a claim for $1,797.73. It is a hearing today regarding entry of garnishments. A judgment entered in this matter some time ago. We had a hearing on April 23rd, 2024 regarding an installment payment plan. Then we had another hearing on May 20th of 24, and I signed on May 24th. Defendant has entered a payment plan of $65 per month. And then plaintiff has filed a petition for periodic garnishment of your wages, the Family Health Center. So set up for a hearing. Normally they can't do a garnishment when there is a payment plan in place. So Mr. Baxter, can you enlighten me here? Am I missing something?
No, Your Honor. Actually, I have some good news for the court, Your Honor. Wendy Davis has paid the judgment in full with her credit card. We're hoping that that will go through and that we will not be before the court any further. We would still appreciate an order setting aside the installment payment order in case things go haywire, which we don't expect at this point. And that we hope to be filing a satisfaction of judgment with the court, Your Honor. So with that, I'll turn it back to you.
All right. Is that true, Ms. Davis? You use your credit card to pay this?
It was a debit card from my bank account, but yes, I was able to pay it in full.
Very good. I'm just gonna tickle this for 14 days to await satisfaction of judgment. If that doesn't work, I can set aside the installment payment agreement and allow garnishment to issue, but I expect that it will.
We would ask that you not enter the garnishment in the meantime. Maybe you were planning to do that anyway, but
no, I wasn't. I wasn't going to do the garnishment in light of the fact there's an installment payment plan in place. I will not execute the garnishment.
Okay. Thank you, Your Honor.
All right, Ms. Davis. Hopefully this will all be resolved. The satisfaction of judgment is a document that says the debt is paid and there's no further action needed in the case.
Thank you, Your Honor.
All right, thank you. I hope your dog Bentley is more cooperative. All right, you're all good to go. Thank you.
Thank you, Your Honor.
Thank you.
Requesting that you adjourn your second hearing, your 382, to take it off the docket.
All right, I've got it right here. All right, thank you. Let me give you this one, Michelle. We'll wait 14 days. She's paid the debt. I think that one's gonna go
Do you
away,
want me to take these three ladies?
please. All right, I have another matter which is set for 10 o'clock. It's entitled Acceptance Credit Acceptance Corporation versus Andrew Babick and Morgan Olson Truck Body. Please accept this email as a formal request to withdraw our motion for tomorrow. This ended up being a garnishment defendant case. They got a judgment or asking for a judgment against the debtor's employer. Looks like it's been resolved. So they withdraw their motion for garnishment. When I don't know what the deal is, or I'm confused, or there's some issue, I set the matter for a hearing, particularly in the Zoom era, where the attorneys don't actually have to drive here. But what it usually does is get somebody to take a look at it and resolve the question. They had asked to seize property from Morgan Olson in light of this debt. I don't know if they were going to go into the factory and take the equipment off the floor or what. So I set it for a hearing. The lawyers talked to each other and resolved the matter. In the last case, they had asked for a garnishment of wages when there was an installment payment order in place. And generally, you can't do that. So I didn't know what to do, so I said we're hearing, and that matter also looks like it's resolved. Pre-Zoom, they would have either had to send a lawyer out here from Detroit or hire local counsel to appear on their behalf. But with Zoom, we can generally take care of things remotely. That's a benefit for all concerned. All right, our next matter, Golden Pond Estates, isn't for a few minutes yet. So I'm going to do the order dismissing the matter in Singh v. Harris. Ms. Gritzbacher, can you hear me?
Yes, I can, Your Honor.
All right, very good. You're in the right place. Let me put you in the waiting room while we wait for the attorney to come.
the money, post your bond, comply with your bond. If you want a court-appointed lawyer going forward, you'll have to fill out a petition for one. You're a pipe fitter?
Yes.
How much do you make?
Not much this year. I've been.
How much do you make?
An hour and I'm sorry, it changes every year. Let's just say 80,000.
All right, so I'm not gonna appoint you a lawyer on a drive while suspended. So you're gonna have to go out and hire your own lawyer if you want a lawyer, okay? All right, good luck. You'll go down the
Judge?
hall, you'll get your notice. Yes.
I didn't hear the first part. I was muted in the courtroom. Could you give me the date and time, please?
Sure, and that was my fault. I kind of slipped through that. February 18th at 10 o'clock in the morning. So John, you're gonna have to
thank
walk
you.
out with him. He's gonna have to get his bond and we'll go from there, okay? We got an ATM here is what I'm trying to tell you nicely.
No, I understand that. I did the amount I was curious.
$200.
Yeah, that's what I mean.
All right, thank you.
Yeah, thanks.
Gregory Mercer Light III.
Yeah.
Gregory Mercer III, 24W834-840.
Good morning, Your Honor. Michael Crawford representing Mr. Mercer.
Mr. Mercer, your name?
Good morning, Your Honor. It's Detective Serna, Whittier Police Department. My partner is grabbing him out of the cell right now as we speak.
Sorry, okay. My apology. I didn't know he was in custody. I thought he was here. That's my fault. Are you here on this one with Mr. Haitian? Yes. Let's do that one first. People against Daniel Timothy Lopes, 26I700547. And I'm told that I was just told by my judicial clerk that the victim is online. Mr. Haitian, your appearance?
Your Honor, good morning to you, the staff. Vincent Haitian, P76506, with and on behalf of Mr. Lopes, who's president to my left.
Good morning to you. Your name?
Detective Constantine, Secretary with Grosse Hill Township Police Department.
Sir, your name?
Daniel Lopes.
All right, so this is the charge of assault with intent to do great bodily harm and aggravated assault. For purposes of arraignment, Mr. Haisha.
Wait forward, stand by my lead, Your Honor.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, Your Honor.
You have the right to be represented by a lawyer, not only today, but your lawyer at all subsequent court proceedings. And also, if you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by your lawyer at that questioning. Do you understand that?
Yes, sir.
You also have the right to a probable cause conference on the felony charge. At the probable cause conference, your lawyer will discuss this case with the prosecutor. If there's no resolution, we'll proceed to the preliminary exam. At the preliminary examination, as the count one, they have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, then the case would be dismissed and you would be discharged. At least that count. You have a second count, a misdemeanor, that's a 1 year, but you don't have any right to an exam. Do you understand what I said? Or
Yes, Your
it's kind of jumbled. If you need me to repeat it, I will.
We've gone through it, Your Honor.
Okay, good enough. Let's see here. Probable cause conference. Heather, I don't know if I have one here.
You know what, Judge? I don't think we did. So let me get you. It looks like that would be February 10th.
Yeah, and then the 17th, right?
Yes, and that'll be at 9:15.
The PCC
Yes.
and the exam at.
That will be, let me get to her 17th here, at 11:30.
Okay, so Mr. Haisha, we're going to give you February 10th at 9:15. That's in front of Judge Hessen.
That'll be Zoom hearing for the problem.
Yes. And then the preliminary exam, obviously in person, that'll be at 11:30 on February 17th. Okay, now, so that's where we are, and I'm going to let you address bond. And where's the victim? Are you the victim, Mr. Caruth?
Yes, Your Honor.
Okay, I'm going to let the lawyer address bond, the prosecutor, I'm sorry, the detective, and I'll listen to what you have to say before I set the bond. Okay, can you tell me your name?
Eric Caruth.
All right, just bear with me 1 second. And by the way, before we go on, has he been printed yet?
Oh, yeah.
Okay. All right, go ahead, Mr. Haisha.
Your Honor, my client is 37 years of age, originally from the Massachusetts area, with school at Penn State. eventually matriculated to Michigan. He has been a Roseau resident for the past nearly 5 years, where he lives with his wife and 2 children. He is the next door neighbor to Mr. Caruth, so we aren't objecting to any type of no contact order. In fact, we understand that there is going to be a no contact order. I just want the court to be aware that my client, by the nature of his living situation, is going to be in some sense of proximity towards Mr. Caruth. However, he understands he's not to speak to him, contact him, or have any contact with any of his associates, third party or otherwise. I want to indicate that he is currently a vice president at Loan Depot. He's held that position for more than 8 years.
Loan Depot?
Loan Depot, yes.
Okay.
He's in the mortgage industry, properly licensed. He is here with retained counsel. We've been in contact with law enforcement for months on this file. This was not a surprise that this proceeding ended up taking place to the extent that it's happening right now, and that we're aware that we need to be in court. However, there were significant strides made in an attempt to resolve these matters prior to coming in today. We're here as it stands. I want to indicate, as it pertains to, not to dive into a full factual analysis of this, but it pertains to the fact of this case, Your Honor, and I don't say this lightly. This is one of the more significant overcharges that I can imagine seeing in my 15-year career in law. I don't say that lightly before this court. The sum and substance of this, and I've seen video in this case, revolves around a mutual stepping outside at a establishment in Grosio between these 2 gentlemen. And what I can gather,
What establishment was it?
this was at Lloyd's.
Okay.
And from what I can establish, is a one push incident where Mr. Caruth ends up falling back, and I can only understand it to be that he believes that he was injured as a result of this. And then the prosecutor took a look at some injuries or alleged injuries and made a decision on that basis. But I just want to be clear that the conduct alleged in here is on video, and I've seen this video, and as an officer of the court, I'm representing the court. My understanding of that video is a single solitary push. Not to state anything beyond that, that is my understanding of it. With that said, with the fact that my client has no criminal history, is college educated, has all of his ties, meaningful ties within this community, is here and is cooperating with law enforcement, has retained counsel. He has no desire or necessity, frankly, to flee the jurisdiction. My position would be that a high personal bond, a high reconnaissance bond, is appropriate with no contact provisions, Your Honor. I would also note, and to the extent that this is germane, that there was a money demand made on behalf of this victim, where he proffered a potential exchange of the dismissal of criminal charges. So whatever value that is, or I think it's important to note for the record as to what the motive of this particular victim might be.
Tell me what happened. I don't know if I did this signing on record. Did I do? I didn't do this, did I? No, I wasn't
It's
here.
actually Detective Delpia's case, and I'm just filling it for her.
Well, if it was done on the 23rd, I wasn't here. Tell me about it. What happened?
This is I don't want to say it's a neighbor dispute that started with some fence line, a tree, pool filter that escalated to somehow both families ended up at Lloyd's with some type of conversation in the building, and then ultimately our victim and Mr. Lopes ended up outside is where the altercation happened. He is correct. It is captured on video.
Well, what kind of injuries did the victim have? I'm going to ask him in a second, but I'd like to know.
Your Honor. Like I said, it's just, I came in to do a totally different case to sign on the record. That's why I'm dressed the way I am.
What happened, Mr. Caruth? You're free to, I trust that you're going to address the court. That's why you showed up. You're free to tell me what you'd like to say.
My injuries, I had to have my ACL replaced and my meniscus, had a bucket handle tear of the meniscus and a impact fracture of the tibia. So I had to have 20% of my meniscus removed and then an ACL replaced.
Coincidentally, I just want the court to be aware that despite these purported injuries, Mr. Caruth did walk into the bar, finish his meal. This is again on tape. I've seen this tape. Finish his meal, walked back in with my client. My client was not attacking him or otherwise. They sat down. My client left. Mr. Caruth finished his meal with his wife, eventually left the bar. And we have video, this will come out during the examination, of him up and down his boat ladder within days of this incident.
Do you have the police report with you?
I do not.
So you, yeah, they
I apologize
got,
for not being prepared. Like I
They gotta send that to you. I mean, I don't want to play a guessing game here. I'm getting two entirely different stories. How much does your client make?
My client makes me, it's over 6 figures per year.
What are you asking for?
Just for show the court.
Did he push you down, sir? Is that what happened? You don't
He
have to
punched
be,
me.
pardon?
He punched me twice and then shoved me down to the ground.
10,000, 10%. You cannot leave the state without the consent of the court or violate any law or ordinance. What is your address, Mr. Caruth?
8675 Cadillac Circle.
All right. No contact with Eric Caruth. You cannot write, phone, see, text, email, or communicate with him in any way. You're not to have any contact with prosecution witnesses at all except through your lawyer. You're not to enter the property address at Lloyd's at 8961 Macomb in Grosse Ile or at 8675 Cadillac in Grosse Ile. No firearms, no dangerous weapons. You do have to go over, so you cannot possess dangerous weapons or firearms. If you have any, you have to surrender those to Grosse Ile Police Department by 1 today. You also have to go to the Grosse Ile Police Department, be fingerprinted and photographed by 1 o'clock today, January 30th. Okay?
Judge, I just one other aspect about it. I understand he's going to remain in the state of Michigan. He does have a 3-day
when is that?
Personal trip from the 9th of February through, excuse me, let me just pull my days up. That would be from the 5th of February through the 9th. He would be in San Francisco.
Okay, you can leave the state to go to San Francisco between February 5th and February 9th. Okay? What is it with all the Grosse Ile boundary disputes? I've never seen anything like this. It's crazy. I don't want to say, it's just, all right. Thank you. Good luck. Thank you, Mr. Caruth. So you understand the dates, correct, sir?
Yes. Yes, sir.
All
Your
right.
Honor.
Good luck. Good luck to you as well. Have a good day. Thank you.
Thank you.
Cherokee, Kathy, Myers, Jen, is this the one I called? 25W8391156, or did I call the other one, Detective? My apology. Gregory Mercer III, 248-34840. Mr. Mercer, your name?
Gregory Mercer III.
All right, Mr.
Michael representing this morning.
All right, for purposes of arraignment.
You're on, like I said, we wait for the truck. Just.
All right, I'll enter a not guilty plea. Where in the world has he been? These guys don't show up. I don't understand. Where you been, Mr. Mercer?
Well, last year I was taking care of my mom. She was in hospice, and I just left the house on my birthday. That's how I got pulled over.
My client was taking care of his mother in hospice. She passed away at the end of last year.
I'm really sorry about that.
He used all his money to pay for that funeral. That's why he didn't pay for this. And
This was in 24. He was supposed to be here and take care of this. He didn't show up twice.
I'm standing right.
$100 cash bond. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. I hope you can post that. Can you post that? $100. $100.
Today?
Yeah.
I have $80.
How old are you?
22.
You gonna grow up a little bit, or are you gonna act like a fugitive the rest of your life?
I'm gonna grow up.
Well, I hope so. I'll make it 80 cash. Don't miss again. You got me? Just show up. Talk to the judge. We're not that unreasonable. We'll give you an extension. This stuff about ignoring courts like this, I don't get it.
Yes, sir.
All right. Release them February 9th at 10. You'll be in front of Judge Hessen. Cherokee, Kathy, Myers, Jennings, 25W839156.
Yep, right here. Just go in front. Take your name.
Cherokee Myers.
Where has she been? Where you been? What do you want to say?
Your Honor, it's a similar circumstance.
I got every excuse in the world. You know what? I don't know. I'm going to write at least one book, but one might be the 2,972 different excuses I got. What's her excuse?
Your Honor, again, my client has just been kind of caught up with some difficulties in life and
What kind of difficulties? Ma'am, what kind of difficulties? Yeah, I'm talking to you.
Oh, so I'm a dental assistant and we kind of went down on hours due to our docs leaving.
Wait a minute, I'm having a hard time hearing you. Get closer to that device, will you please? Say that again.
So I'm a dental assistant and we currently are having a little bit of difficulties being that our hours are getting cut due to
Hey, I didn't hear that last word. You're a dental assistant and what? You were having difficulties with what?
So our hours are getting cut down at my office due to the docs leaving, which leaves us no work to do. So I've been out of like hours for the last 2 months, just waiting on my manager to tell me when to come in.
Yeah, how many hours did you work in the last 2 months?
I was part-time there for about, I would say like 14 hours max.
A week?
And then I had another position in Detroit where I worked Wednesday through Friday. So I was full-time.
Why does that have anything to do with you not showing up here? Tell me, I gotta know. Why didn't you show up?
Not gonna lie, life has been a little crazy for me. So I kind of got distracted and forgot.
Ma'am, how much money do you have on your person? Otherwise, I got to set a bond you're not going to make. How much money you have in your possession right now? I'm asking you a question. Do you know I'm talking to you, ma'am?
Yeah.
How much money do you have?
I just spent my last $70 on my DTE.
anything, Your Honor.
All right, look, it's not that old as far as people not showing up go. I'll give you a personal bond, but stop doing this. You do this again, we're gonna have a big problem. Personal bond. Ma'am, I'll tell you what I'm gonna do for you. Well, let's just set up a payment plan.
Your Honor, we work on a suggested payment plan that I hope the court won't find disrespectful. My client is saying that she can afford to pay $30 a month starting February the 27th. So
I'll tell you what, I'll do that. You pay $30 per month beginning February 27th. Now, if you don't have the money, you call the court. I'll dismiss the show cause right now. We'll go on Zoom, or you can walk in here on or before one of the due dates. I'll be glad to give you an extension, but don't ignore me again. I don't like this. I don't know too many judges that don't get agitated by it. You got me?
Yeah.
You're not bigger than the system. You follow me?
Yeah.
All right, that's what I'll do. They'll release you. Good luck.
thank you, Your Honor.
Thank you.
Thank you, Judge.
Edward, Michael, roll 21B 139-703A, 22B 1415608, 22B 1415660B, and 22B 1415660C. So appearances, please.
Morning, Your Honor. Mike Kilcroft, representing Mr. Roll. Mr. Roll, please state your name for the record.
Edward Michael Roll.
All right. Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Let's see. I don't get it. So let's start with A, B, and C. He's got to suspend drug paraphernalia and false information from 2022. Let's start with those. What does he wish to do?
Your Honor, I would like to stand mute, wait for my
Not guilty pleas are entered on all of those. He hasn't shown up on those cases. And then I've got another probation violation over here. And I'll come back to these files and set a bond. So give me what he's going to do on the probation violation, which is in front of Judge Hudson, 21B 139-703A.
My client guilty to all the allegations.
Is that what you want to do, Mr. Roll?
Yes, Your Honor.
Hang on. I didn't ask you to speak yet. Just let me finish.
Yes,
You
sir.
got multiple violations here, and you have not been here since you were supposed to be here in 2022 on this case. It was adjudicated. I have a 4, 5, 6, 7 count show cause, and your lawyer tells me you wish to plead guilty to all 7 counts. Is that true?
Yes, Your Honor.
You've absconded, so you could get the maximum, which is 93 days in jail. Do you understand that?
Yes, I do, Your Honor.
Now I'm going to take the plea, and then I'm going to go ahead and have to send it back to Judge Hessen for sentence. I hope everybody understands that. Do you understand that, Mr. Roll?
Yes, Your Honor, I do.
And you do, right, Mr. Crawford?
Understood.
You're charged with these 7 counts. If you plead guilty, like I said, you could get 93 days. And I want you to understand that your probation could be revoked. And what happened to my oh, here it is. I'm sorry. All right. You have certain rights before we proceed with the hearing. If you plead guilty, you're giving up your right to remain silent, your right to a hearing, your right to cross-examine probation witnesses, your right to bring in your own witnesses, your right to testify or remain silent and not have that silence held against you if you choose to exercise that right. You have the right to cross-examine their witnesses. If you plead guilty, you're waiving your right to a hearing of any kind. We won't have a hearing. The convictions or probation violation charges would be deemed admitted, and then Judge Hessen will sentence you on that. Do you understand that?
Yes, Your Honor.
All right. As the count one, that from the show cause dated 7/27/22, how do you plead to the charge of failing to attend your probation visits on July 12 and July 27? Guilty or not guilty, sir? Talk to me, not her.
Guilty.
Did you fail to attend your scheduled probation visits on July 12 of 22 and July 27 of 22?
Yes, I did, Your Honor. Guilty.
To the charge you failed to attend the victim's impact panel, how do you plead?
Guilty.
You failed to attend the victim's impact panel.
Yes, Your Honor.
To the charge you failed to pay your fines and costs as ordered, balance 1821, how do you plead?
Guilty.
Did you fail to pay those funds?
Excuse me, Your Honor.
Did you fail to pay those fines and costs?
Yes, Your Honor, I did.
To the charge that you failed to schedule and attend your 7 days on the court work program, count 4, how do you plead?
Guilty.
You failed to do that.
Yes, Your Honor, I did.
To the charge that you failed, this is count 6, that you failed to provide proof of completing 24 hours of community service by September 21 of 22, how do you plead?
I plead guilty, Your Honor.
Did you fail to do that?
Yes, I did, Your Honor.
To the charge that you failed to, well, this is count 5, failure to submit to weekly testing, how do you plead?
Guilty, Your Honor.
You failed to do that.
Yes, I did.
Count 7, that you failed to attend and complete an intensive outpatient treatment program, how do you plead?
I plead guilty, Your Honor.
You failed to do that.
Yes, sir.
Anybody force you to plead guilty?
No, Your Honor.
Pleas are accepted, all 7 counts. They'd only be paying him a couple $1 million if he was playing in the major leagues. He just went 0 for 7. He doesn't show up. He's got no respect. Go ahead. What do you tell me? Well, there's nothing to say other than we're going to address bond here.
Yes, Your Honor. My client would like me to let the court know that his reason for not appearing earlier is he's had transportation problems.
He lives in Allen Park. Is that what you told your lawyer? I don't want to know what you told your lawyer. I don't want to know. Don't answer that. Transportation problems.
Yes, Your Honor. Even in terms of working, Your Honor, the only way he gets to and fro work is that his employer is willing to come pick him up and bring him to the job site.
Yeah, what do you want to say, Detective?
Your Honor, and during my conversation with Mr. Roll this morning, it's my understanding that he had some serious issues dating back to 21 and 22 involving substances and drugs and alcohol, and he was living in between several places. that may have contributed to his failure to appear. I'm not providing an excuse, but those are the things that he tells me. He tells me he's been clean for 4 years and wants to accept, the reason he's accepting responsibility today is because he's trying to turn his life around before he turns 60.
How old is he?
59, Your Honor.
So that's your cutoff date, 60, huh?
It's gotta be some kind of date, Your Honor. This is getting old. And I'm getting no younger.
On 2560 A, B, and C, 2,510%. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to give you a date here. Those are going to be on February the 4th at 10:15. You'll be in front of Judge Hessen on these cases. Arraignment, pretrial, February, or pretrial, I should say, February 15 at 10, I'm sorry, February 4. What am I saying? February the 4th at 10:15. So you're going to have to post $250 to secure your release on those charges. And those are the bond conditions on those. Again, no alcohol, no marijuana, no illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court as directed. All those same bond conditions apply to the other charge, the drunk driving or impaired driving charge, 40,000, 10% on that. So same bond conditions. You're going to have to post $42.50 to secure your release. That will also be in front of Judge Hessen. That will also be on February the 4th at 10:15. Any questions, sir?
No, Your Honor.
If you somehow post a bond, I'd strongly suggest you come back. Do you understand what I'm saying?
Yes, I do, Your Honor, for sure.
All right. That's it. Good luck. Thank you. Have a good day.
Thank you.
Thank you, Your Honor.
Thank you. Perry, John Patrick Perry, 26I-701030. Thank you, Mr. Crawford. Thank you. Your appearance, raise your right hand, solemnly swear affirm and the penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you guide.
Yes, sir. Your Honor.
You know what? You could probably do this one down the hall. I'll take it. It's just in the future.
Yeah.
Go ahead.
You sure?
Yeah.
Okay. On Monday, December 8th, 2025 at approximately 3:07 PM, Officer Canterbury was operating stationary radar east side of Meridian near Meridian Elementary School. Radar was in stationary mode. He observed a gold colored 2012 Ford Escape, Michigan registration, EYW 3193, driving at a high rate of speed. Radar gave it an indication of 53 miles per hour with a consistent tone and a 35-mile-an-hour zone. Canterbury followed the vehicle, which was disregarding police lights and sirens, up East River, and eventually came to a stop at McColeman East River. Patrolman Canterbury made contact with the jet driver, who was the sole occupant, who was John Patrick Perry. While speaking with Mr. Perry, he noticed glassy eyes, watery eyes, cheeks. During the conversation, Mr. Perry did admit to having 1 to 2 drinks that day. Knowing that Mr. Perry has a warrant for his arrest on Hillsville Township for a misdemeanor OWI, Mr. Perry was placed under arrest for the warrant, and it was decided to conduct standardized field sobriety test, safety of the booking area of Hillsville PD. Mr. Perry failed the horizontal gaze. He also failed the column test. He also failed to pick a number between 10 and 12. He also could not perform a finger to nose test. Mr. Perry was read his preliminary breath test rights, which gave a result of 0.16. Patrolman Canterbury then read the chemical test rates from DI 177. The test results on the Toxilizer 9000 were 0.13 grams of alcohol per 210 liters of breath. Test number 1, test number 2 was 0.13 grams of alcohol per 210 liters of breath. All results were entered in lean.
That's good. Based on your sworn testimony, I find that crime OWI was committed. There's probable cause to believe it was committed by the defendant. I'm going to ask you to sign this. I know you signed it on the 27th.
Yes.
But I waited that out since we're doing the signing on record today. I'll just ask you to sign the complaint there. And there is, again, probable cause to believe that the crime of OWI, excuse me, OWI was committed, probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint and the warrant. So
in the county have been purchased by large companies, have out of county council who represent lots of parties, and the whole landscape of landlord tenant law in mobile homes has changed.
Judge, I know that Attorney Cromendike is on his way. He and I were just on the phone.
All right, he's here. Mr. DeWitt was here, Mr. Sickle, and I was a little bit taken aback by all of it.
Good morning.
Good morning. Mr. Cromendike, I know you were disappointed, but you didn't get to come out to Centerville this week, but maybe we'll still get a chance.
I don't know if disappointed is the word, but
all right. We've got two Golden Pond cases set. We've got Golden Pond versus Gritzmacher and Kelly Cantrell. We were here last week and Mr. Sickle was here from Mr. Cromendike's firm. And we did get some struggles on trying to figure out exactly what was due and owing. Ms. Gritzmacher, can you hear me?
Yes, I can, Your Honor.
All right. I would also note that Meg Bauer is also present. She was privy to last week's discussions. She indicated you guys have been on the phone. Regarding Miss Gritzmacher, she was going to try to get some emergency help from DHS.
I think we were on the phone about Cantrell.
All right. Well, what do we know about Miss Gritzmacher?
I have not had any communication with Miss Gritzmacher or with Meg about Miss Gritzmacher.
All right. Well, we determined that rent was $1,614.59. She was included a $300 payment, $249.20 in costs, for a total of $1,863, and $300 was for repairs made. So at the time we were here last, through January, that was the amount due and owing. Do you agree with that, Mr. Cromendike?
Yes. Yes, I do. Those are the numbers.
All right. Ms. Gritzmacher, were you able to get any help?
I did fill the papers out, and at that time they said I need to redo another one, and I did take it. I did just it got rid of my car, so to where come on the 3rd, I would be able to give $700 a month to get this all taken care of, so I don't lose my home.
Well, this is through January. There'll be another month rent due on February 1st. So the number I'm gonna give you is just through January. Is
Okay.
$1,313, $300 for those repairs that were made, and $249.20. This is through January. I used to add the upcoming month, but there was a hearing in circuit court on an appeal, and Judge Stutzman ruled that I can't do that. Some judges do it and most judges don't. At any rate, what you owe is $1,863.79 within 10 days from today, which would be that's third isn't right. Today is the 30th. We do by February 9th. Now, Ms. Villa, the manager, is here. You indicated you've got maybe some help coming and you plan to try to pay an additional $700.
Yes, on the 3rd, I always get my checks, and with my check, and I just rid of the car because it's not running, get in trouble out here, and I got in my Social Security check and put with that, and I would have $700 this month.
All right. Now, my suggestion is that you contact Ms. Villa today and discuss this with her. I'm going to tell you something.
Who is that?
She's the manager at Golden Pond.
Okay, see, I did not even know who the manager was of Golden Ponds.
All right, well, there've been a lot of
I thought it
changes
was
there. So,
KC Villa.
yes.
Okay.
All right, let me repeat. You owe $1,863.79 by February the 9th. If you don't pay that amount, you're subject to have them take your trailer off the lot. You don't have to move out. They're evicting your trailer because you own the trailer and they own the lot. This is lot rent. Now, they don't have to do that. In fact, it's in their interest not to do that. It's in their interest to try to work out some sort of payment agreement with you so you can stay there. You have to pay the entire amount. A partial payment will not prevent the writ of eviction, and there is no money judgment due. However, well, they did ask for a money judgment. So I guess I'll issue it. This is only through January. Do you understand, Mr. Cromendike?
Yes. Yep.
All right, there's a money judgment of $1,747. So my strong advice, Ms. Gritzmacher, it sounds like you've got a plan to pay this off. They don't have to evict you on February 9th. They have 56 days from the day to ask for the writ of eviction and another 56 days to serve it. So they have about 100 days they could agree to work with you to try to get caught up on this rent. And it's in their interest, so they don't have to hire a company to come in and have your trailer taken off this lot.
Okay, Your Honor, I got a question. You said they did $300 maintenance. What did they do for me for $300?
Well, we discussed that last week. Let me see if my notes tell me what that was.
And I can help you out on that too, Your Honor,
Yeah.
if you'd like me to. That is that's relating to some skirting repair. And I'm actually looking at a skirting installation payment agreement here, where you had agreed, Ms. Gritzmacher, to pay $100 a month. So they paid 2,000.
Yeah.
I'm sorry?
Yes, you're correct on birding.
All right,
Okay.
Very good. All right, now, do you know how to get a hold of Miss Villa?
No, I don't, Your Honor.
Ms. Villa, could you join us, Ms. Villa?
Oh, I'm sorry, I'm on mute. Yes, Your Honor, good morning.
How does she get a hold of you?
Yeah, we have a phone number, sir. And I've been speaking with her previously.
All right, well, I'd ask you to stay in contact with her. And if you're gonna work out some repayment, I think that'd be best for all concerned. All right, she knows how to get a hold of you. And you guys can discuss this further. I think you're gonna work this out, but let me repeat. Be a $1,863.79. There'll be an additional $400 due on February 1st. So the amount's gonna be $22.63, perhaps plus a late fee. You're proposing to catch it up at paying $700 on a $400 a month lot rent. They can agree to do that, but they don't have to. That's why you need to stay in contact with your manager. All right. Ms. Villa, will you call her today?
Yes, Your Honor.
All right.
Your Honor, I need to give her my new phone number.
All right, let me put you guys in a breakout room because I don't want you to put that out over the live feed.
Okay, thank
And
you.
you guys can exchange contact information.
Got it, sir. Thank you.
Judge, I am wondering
Thank you.
if you can spare a few minutes that Ms. Cantrell and I might be able to speak in a breakout room.
Yes, let me,
unless she objects
this
to
should
that.
just take a minute. And you guys join that room and then Ms. Villa, if you'd come back to us.
Yes, Your Honor.
Judge, are you putting that judgment together or did you need me to do that and submit it?
You sent me one, so
Oh, we
I've
did.
done
Okay,
it.
perfect.
So I appreciate that. All right, Ms. Cantrell, can you hear me? All right, this is another Golden Ponds case that we struggled with last week with Mr. Sickle. And it's entitled Golden Pond Estates versus Cantrell. Once again, their manager Casey Villa is here. Defendant Steve Cromendike. And Meg Bauer. Ms. Bauer and Mr. Cromendike have been discussing the case. Last week, we came up with $1,932, late fees at $60. There was other utilities for November and December, $249.30. We came up with a tentative figure of $2,306.45 through January. There were water bills, utility issues, and $72 per month for sewer and water, and it was hard to exactly pin the number down. You guys have been in discussion. Ms. Villa has joined us, so let me put Ms. Bauer. Well, all right, before we do that, what number are we working from, Mr. Cromendike?
That you had $2,306.45.
Yes.
Yes, that's my understanding of what the number is as well.
All right. Ms. Cantrell can hear me. She's there. Let me use the breakout room. And I'll move. All right, I'm going to put Ms. Bauer and Ms. Gritzmacher. I'm just going to remove her.
Okay, Your
All
Honor.
right. What's that?
I said, okay.
All right, you're good to go. So let me do Kelly Cantrell to room 1, legal aid to room 1. All right, you guys can talk privately. Ms. Gritzmacher, I'll remove you and you can go on with your morning. Meg, did you get the join button?
I did. I see Miss Cantrell's still here. Miss Cantrell, did you get a? Oh, there it is.
She's gone.
Okay, thank you.
All right, I have then with me Andrea and Brady Watson. And I have Andrea Watson also. Mr. Brady Watson and Miss Andrea Watson. This is file number 252671. Your lawyer has filed, or the lawyer for the Larkins has filed a conditional order of dismissal. They find that the amount due is $4,009.93. You agree to make weekly payments of $450 every Friday until the balance is caught up. This will take 19 weeks. They further agree that if they missed or have any late payments, they can result in an immediate eviction. So you've agreed with your landlord to pay an additional $450 per week to get caught up. Is that correct?
Absolutely,
Yes,
Your Honor.
All right. Well, Ms. Watson, you look like you're out in the cold. I've signed that conditional order of dismissal. We'll make sure you get a copy of it. You can both go on about your business and the matter's dismissed. If you hold up your end of the deal, it'll take care of it. If you don't, they may ask for an immediate eviction. But
Okay.
you're good to go.
Right, thank you, Your Honor.
Thank you,
All
Your
right,
Honor.
thanks. All right. That takes care of our 1050 case. Larkins versus.
So this states that the lawyer will not be here due to having a protective order hearing in another county, which was, I've not heard anything like that, but what is appropriate is for the judges to tell other judges when they understand that there's another function to tell them they've got to protect, which was not done in this case, which makes the difference between the way some judges do things and some judges don't. We're just going to rotate this to next week, I guess. We'll have it on Monday. You don't have to have a resetting, and what we'll have you do is every day thereafter, you will show up until your lawyer shows up. Because something something needs to be done on this one. You've changed lawyers from Mr. Adams, haven't you?
Yes.
Mhm. Okay, yeah, get a resetting to a Monday, please. Thank you. We'll go. It's ironic because we've got the most dispositions of any court in the whole region. And these other judges are allowing protective orders so that they can, but maybe they need to, maybe it's important they catch up with us. Maybe they can use the time to catch up to us, but they won't be able to. We have a fast pace here. We're the Olympians. Reagan McLean? Is that James Patchett? Huh? Is James Patchett still your attorney?
Yes, sir.
Have you seen him at all today?
I just texted him, I told him I was here.
Well, I know that's nice, but you don't need to be texting him because he should be here. Did he say he was going to be on his way or something?
He said, okay.
He said, okay. Well, he's late. I hate to say. You just have a seat. Thank you. Markham Champagne.
Yeah. That's going to be a plea, I believe.
Where's Brett? Is he working with him right now?
Yes.
Okay, looks like there's two cases. Then Gregory Renfro.
That's right, Your Honor.
This says Brent Turk, go on.
Yeah.
The docket before I changed it, Judge.
Can't believe it.
I'm trying to, his mother's funeral was tomorrow, and I was trying to sit the court.
Sir?
His mother's funeral was tomorrow, and I was checking to see if the court would allow him on this motion.
Okay, bring him in. It's Gregory Renfro. Please note the Kidler is now the attorney.
Yes, sir.
Did you file the?
It should be, I did it
Substitution?
last night, it should be default. I've been getting behind because it's finished. That's the, I don't have it printed out, but that's the funeral announcement
Okay.
for this morning. Yeah, we're in for a call. Funeral. Tomorrow.
Okay, is there a prosecutor maybe on this one?
Who's this, Jeff?
Gregory Renfro? This one's Daniel Boyd. You filed a motion a long time ago. See, there's, I don't even know the facts right now, but I'm looking at this and something doesn't smell right at all in all of this.
I didn't see him on my docket, but I guess it's.
Something doesn't seem right at all.
Okay.
Okay, we have a motion to revoke probation that was filed on October 2023, over 2 years ago. Was the defendant an absconder? Anybody?
I don't know, Judge. This was not on my docket. I'm just trying to, so I'm trying to look and see.
It's added late yesterday, but.
That's because.
I know that, but I've done this long enough. Something is not right here. I'm just looking at it for the first time, and a motion was filed over 2 years ago. He's on regular probation for all things evading detention with a motor vehicle. And something tells me that he had absconded for 2 years and had been on the lam. But can somebody figure, there had to be a warrant issued for his arrest on or about October of 2023, over 2 years ago. And looks like this is some
Information shows he was arrested December 16th, Judge, so he would
of
have had.
what?
Of 2025, so he would have had to been an abscond.
I gotta just get it.
Yeah, well, that's not good. If that's true, I'm going to let you out. Well, why would anybody in their right mind do that?
Compassion.
If he had compassion, I got compassion. What he doesn't have is rule following. He was on regular probation. He had been convicted for, of all things, evading detention. So we filed a motion. So he evaded answering to the motion for over 2 years. So they caught him somehow. And now he wants to get let out.
I don't know how the circumstances of him going into custody or
Well,
whether he,
why wouldn't you know that? You're representing him.
I haven't had an opportunity to.
Well, I've just pulled
I mean,
the
we
file
can
and looked
listen.
at it, and I think I can, this is simple enough to figure out. This is just math.
Why didn't you report? Did you not
It-
report for that time period?
Wait. You're gonna ask him things, raise your right hand, because you're under oath. You solemnly swear or affirm any statements that you make during this hearing will be the truth, the whole truth, and nothing but the truth, subject to perjury. So help you God.
Yes, sir.
Lower your hand. Go ahead.
Mr. Redfern, there appears to be a period of time where a motion to revoke probation was filed, and then, around 2 years on that before you were taken into custody. Were you reporting during that 2 years in your disposition?
You were reporting at first, Mr. Harmon, Gary Harmon?
Yes.
Who's the probation officer on this one who can answer for this? Because he's saying some things, and I'd like the probation officer to tell me what is accurate, because I don't rely on this. I'm not going to rely on him. Anybody? Somebody's got to be here.
It's not on the document. That's why nobody.
Who got pulled at the last minute?
Yeah, he did
He files a motion just yesterday.
Because of his, because of his mother's funeral. I mean, I'm not, you only have one mother in this world, and when she dies,
You're telling, what are you preaching to me
I'm not
for,
preaching,
sir?
I'm just saying that's my reasoning is I understand that I'm trying to put in the district attorney's office and perhaps everybody at a disadvantage doing this at the last minute. But the exigent circumstances that we only have, to try to go to this mom's funeral.
Consider rhetorical language. Just tell me what the facts are. That's all I need. You don't have to tell us all we only have one mother.
Well, I'm saying as far as my reason to try to accommodate Mr.
No, but
irrespective of the
But
state.
think of this, what you're going to have to answer is the question of, number one, he's on evading. Number two, he absconded for 2 years.
Well, that's what I'm sorry.
And you can interrupt, I guess, all day long like you have done historically, and we're not going to get anything.
Let's attempt to explore the reason.
Can we just speak one at a time? You know that the court reporter can't take both of us speaking over each other, please. So that's what needs to be answered, is not that his poor mother passed away. My God, my mother is very ill. So I'm not non-sympathetic, but what I have is looking at the circumstances here. He's on probation. We placed him on probation. He pleaded guilty, and he was convicted for evading arrest or detention. That is fleeing. Then for 2 years, he fled from probation, and he had been an absconder for 2 years.
That's what I was attempting to explore.
Can I finish by, this was a solo I was performing. Let me just conclude it. So he absconds, and when was he arrested?
December of 2025.
All right, just last month. So just last month, he was finally arrested after 2 years and over 26 months of evading responsibility. So you can see the concerns this course has. What in the world can I possibly have as a guarantee that he could be released and come back? No, he started off this case. He got in trouble for evading and running from the police when he was supposed to stop. Number two, for two years and 26 months, he's been evading and fleeing his responsibilities. We caught him last month, and now you're asking for him to be released on his own word that he will report back. You can see where that's going to be a tall mountain to climb. Go ahead. You may speak.
What were you doing the last 26 months between the time the MTRP was filed and December?
I was in Rose at Lamar Steakhouse pulled off there for.
You weren't reporting as ordered by the court.
My probation officer, Mr. Gary Harmon, he had retired. And then him transitioned to somebody else and never let me know a new day. And Mr. Harmon informed me to not come up there and report. Was he would take me to jail. We said, keep reporting over the phone. That's what I was doing. So now I went to college. I didn't start a business on my own. It wasn't just running. I've been doing productive things.
You stayed at the residence you've been at since you were on probation.
Yes, sir.
Stayed at that girl.
Yes, sir.
Has any attempt, has any attempt?
Please, hold on. Gator Harmon, where is he? I know, but is he still in the Beaumont area?
No, he's in Houston, sir.
Okay.
You were.
I'm
my term, my probation.
if you think I'm going to take your word without substantiate, you won't. You're going to lose every time with me on your facts. You cannot be trusted by your history, criminal history. You cannot be.
Not procedure.
Go ahead.
If the court were to see fit to allow you to be released from jail, either by posting a bond or having means, what guarantees could you provide to the court that you would return to custody after having your negotiation? How can you assure the court that you would return to custody once you obtained your notice?
What do you mean by that?
Well, how do you represent to the judge that you're going to go back into custody after you attend your notice hearing? He lets you out.
Yes, I definitely will.
You want to get this straightened out?
Yes, sir.
Where and no.
Yes, sir.
You didn't leave the state or attempt to go anywhere.
Awesome. That's not told me to try to pay all my fees off and then turn myself in. What I've been trying to do. I never smoked to.
Are you through? You through?
Yes.
Well, let me tell you what Gator Harmon actually said. On September 14th, 2023, that caused this motion to revoke for 2 years. That you have been AWOL for 2 years. On September 14th, 2023, the defendant failed to report to the criminal district court as summoned. So there we go. You didn't report to the court as you were summoned to do. You failed to report to the probation office for a scheduled visit, alleging medical issues. At this time, the defendant has not produced any medical documentation concerning his absence. The defendant has not made any effort to address his delinquent court-assessed fees since February of 2023, as ordered by the court. It is therefore requested that a motion to revoke probation be filed. He recommended it. The man you're saying was letting you do all of this. He recommended and urged the motion to revoke probation. It was filed and a warrant had been issued for your arrest. And we finally caught you after 2 years.
I missed court because I had COVID. I sent my form in to some later, Miss Kelly. I sent to Mr. Harmon. He received both of them.
Failed to report, asked him to produce medical issues, medical documentation concerning his absence. Never did. And here you are, after 2 years, we finally caught him. Anything else?
I've just asked for the court to exercise some compassion and allow me to attend the funeral of his mother. Obviously, if he doesn't report back, then that would not bode well for the court's disposition of the MTRP in any sense.
It's not going to, no, we've got him right now. We've got him. It's what has been done doesn't bode well for his disposition, but we're not letting him go on my watch. Now that we caught him after 2 years.
But I don't know that he was taking active measures to obey, Your Honor.
He was taking active measures not to report as required.
And I don't think he was.
If you don't report, you're not on probation. And what's good for you is good for the other 5,000 probationers. So if you can just scamper off and decide when you want to report or what terms you want to set for yourself, it's good for every 5,000. That's what's fair, I guess. We're not going to treat you differently. You're supposed to matriculate into the group. That the first thing you do is the first order. You must report as required. Otherwise, you're not on probation. You're on your own probation, which isn't the way it works. What does the state have to say?
Judge, as compassionate as I am and would like for him to attend, it's just.
Yeah, nobody thinks this is, I feel sorry for the family, but not you. I mean, this is, you can't not be trusted.
If it was years ago, we used to do a furlough where they would get a furlough, but they would have to pay a deputy sheriff to escort them from the jail. They would have to pay for his time to escort him there, stay for the funeral, and come back and pay for his salary. And that was the only way we would do it back when they had a conviction like this.
How did you get arrested?
Traffic stuff.
That warrant was only out for 2 years.
I didn't even know about it.
I don't care what it's not what you know or what you say you didn't know. The fact is, it had been an issue for good reason. And you, for whatever reason, they had not been able to catch you until 2 years later. But we're certainly not in a position to let you go free. Not under what you're charged with in the first place, which was deceptive. And now with you were convicted, sentenced to 10 years, right? Yeah. Sentenced to 5 years in prison, probated for 10 years. So you were convicted. And then your statement about Mr. Harmon is completely different for what Mr. Harmon submits in this administrative report that caused the motion to revoke probation. And I don't see anything in the file that states him asking to refute or to withdraw his statements or this motion that he asked to be filed. And without anything else, sir, I'm not granting the relief.
I was just going to add, Your Honor, the court was looking for some assurance that he would attend a subsequent hearing. And obviously, if he misses his granted bond and post bond, and he willfully fails to appear at the next court setting, there's a bond jumping statute that will be filed, and that will be one level above what he's on. This what the case is, which will be a second degree. So he would expose himself to 2 to 20 years incarceration if he didn't. Versus just the 5 that he's exposed to.
Stay asking.
I don't have an objection to a bond being set, Judge, but we'd have a GPS monitor on him, so we'd know where he is.
And of course, if he doesn't appear to the setting.
Hold on. What is this what we do? We're going to open this door right now after 20 years here. We're going to open this door and say that he is allowed on his own, on his good word, which he has defied twice.
I'm just saying, the court asked what incentive or what assurance the court would have that he reappears. It would be his exposure to 20 years.
Well, that was what he was exposed. He was exposed to criminality, additional criminal sanctions in the first place. That didn't deter him.
He would be exposing himself to an additional, it would be a consecutive sentence.
Are you stating you have no objection to releasing him under this?
Not saying just releasing, Judge, but under certain conditions.
What conditions?
Well, my first suggestion, I think, was always the best way to do it, which was they make arrangements with the sheriff's office to have a deputy take him out of jail and take him to the funeral and bring him back. That's the way you know that he's still in custody.
There is no way he's going to pay for that.
The family wouldn't. I don't know if the sheriff's department still does that. So I don't think they do that.
Well, why don't you figure that out?
The only other way.
I'm not being too.
They don't do that.
Sir, I don't think they do. Okay, so let's say they don't. Then what? If they don't do it, what does the state say?
Have a bond and GPS. Set it next week for a disposition. You got a short reset. I mean, it's a failure to report. It shouldn't be too hard. Or having pleaded true to it now and set it for sentence.
What difference would that make? He would abscond and abscond.
Well,
if he absconds, that pleading true doesn't make a bit of difference.
If he absconds, he's exposing himself to a 20-year consecutive sentence on top of just the 5.
That this sort of stuff has happened. This is the situation that's happened before. When has that ever been done?
Not bond jumping?
Where it's been filed like that. You can't even recall it. And
I think state better was the last one.
All right. If there's no objection to the state from the state, then yeah, okay. He's allowed release.
From how much of the bond?
Well, do you have any money to pay for a bond?
Yes, my family does.
How much?
I'm gonna say, I haven't talked to anybody today or yesterday.
Well, it's third-degree felony. He's looking at 10 years and he was looking at 10 years in prison in this. So $5,000 bond. He says have a GPS device as a condition of bond. And he has to report back. He has to report back immediately after the. Yeah.
Okay, you understand? But if you don't, I want to put this on the record too, that if you don't, and something goes amiss here, you don't need this to your next school day, they're represented there and file a jumping case with your exposure you 20 years consecutive to this. All right, you understand?
I have
Right, or we're setting next week for.
That's the other, yes.
McConnell Williams. McConnell Williams. That's yours?
Yeah, Mr. Williams,
Yeah, McConnell
sir,
Williams.
he's here.
Come on up. What are we doing about that? I don't know. It just says announcement.
Yes, sir.
Whatever you want.
Judge, at this point, we might have to need to have a discussion in camera with the court about some matters arising. But at this point, the state has made an offer of 2 years, so Mr. Williams, he does not want it, but we're trying to work with the state on some other matters. To maybe show, to get a better offer, a better deal.
Set the trial. Okay. Joseph Castillo. Get it, counsel. What are we doing on this?
Oh, it's agreed, Your Honor, 18 months, hey, Joe.
Too small, Nicole.
Oh, amen.
I like it actually.
I need a pre-sentence report. Does anybody have one?
I may have one judge, I think.
I do.
I do. Not. You have one there?
Wait a minute, I lied, hang on. I do have one, Judge. My apologies. I wrote it on front of it, but. I wonder if I. Okay, thank you. Yeah. They just got it. I'm giving you. They were.
So showing that provides a urine sample for 2025, which showed all kinds of drugs in his system. By the urine sample in September, cocaine and tetrahydrocannabinol. Looking at his pre-sentence report. The defendant was asked how he will do on probation. He replied, "I am clean. I am going to stay that way. So I will be able to successfully complete probation. I don't talk to anyone or go anywhere. I stay in the house clean and wait on Danny, who is your spouse, to get home. All of my friends are stoners, so I don't hang with them anymore. So here you are with drugs. So you didn't tell the truth, did you? No. You speak English?
Yes.
Speak out. Okay. Thank you. Well, you're not the first one. You're not the first one. Says something before the court so that you can get what you want, and then we come back and we find out that all that was just talk. All right, there's a motion to revoke unadjudicated probation here, 19-31705. Is this contested?
No, true to 1 through 8.
Sir?
True to 1 through 8, all allegations.
We have an agreement for 18 months. 18 months, state judge.
You know what? Lacey, I guess I don't know how to work this pad, but it doesn't work like the other ones do.
It should.
Yeah. I'm just trying to open that one.
Oh, you have to use the, I think the new stylus. Because from,
Yeah, but it's on the wrong end.
do you want me to cut it off?
Yeah. What are you talking about?
The string?
That's what it is.
Yeah.
It's the stylus is fixed and fixed to this.
Yeah. So from my understanding, Judge.
But see, this doesn't, up at the top, it doesn't give you any slack.
I mean, I can cut it off the string if that works.
You might try rotating the tablet, Judge. It may rotate with you.
We're not. Okay, that's a waiver formal reading at the end of the motion to revoke unadjudicated probation. Can we proceed in some?
Yes.
Raise your right hand, sir. You solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. Lower your hand. In summary, it states that on November 15th, 2019, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of illegal possession of controlled substance. Is all of that true?
That's
right. Something doesn't make sense in the full page of this because if he's on probation November of 19, he would have been off probation November 5 years would have ended November 24. This was filed on October 17th of 2025.
You signed the extension in July of 24 for 2 years.
Okay.
That's accurate, Judge.
So that 5 years deferred or unadjudicated probation was extended 2 years, which would have then resulted until what, 2026, I guess. And this motion was filed on November 15th. Was filed on October 17th of 2025. So you were on probation in this case, correct? And this is probation for the state jail felony of illegal possession of controlled substances. All right. We're not going to do 1 through 8. We're just going to do 1. We only need 1. How about number 2 states the defendant provided a urine sample on or about, providing a urine sample on or about. No, that doesn't make any sense. Providing urine sample on or about for scientific analysis on or about. Let's take the first on or about out, okay?
Yes, sir.
We're gonna. Provided a urine sample for scientific analysis on or about August 8th, August 11th, August 12th, September 9th, all 2025, that showed the presence of metallic byproducts of barbiturates, benzodiazepine, and tetrahydrocannabinol marijuana in violation of condition 10 of your deferred or unadjudicated probation order. Is that allegation true and correct as it is alleged?
Yes, sir.
Are you pleading true and correct?
Yes, sir.
To it voluntarily and because it is true as it is alleged?
Yes, sir.
You understand that a true and correct, truly and correctly pleading to a violation of 1 or more conditions of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked. You can be sentenced to no less than 180 days up to 2 years.
Yes, sir.
In the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
The agreement has been reached where you would be pleading true. Your probation would be revoked. You would be sentenced to 18 months in the state jail. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
Okay, I got a problem here. How does it erase things?
You have to push the button on the pen. There's a button.
Where's the button on the
Right
pen?
here. Push the button and
You got to hold it down.
yeah,
Judge.
hold the button down and then it's
It's just, what is that? I don't know. I don't know where it is. I'm supposed to get
the button. The button. So. And hold it down and then erase. That's what they told me.
all it's doing is putting ink on it.
If there are 2 buttons, I think it's the top button.
Yeah.
I tried both.
Yeah.
They're doing this, they're just throwing ink on it.
Technology.
You have to hold them both now at the same time.
How do you do that? How do you do that? With one
I
thumb?
put my thumb on there.
What's not happening? Okay. All right. If I follow this, you have no right of appeal. You understand?
Yes, sir.
Show you, sir, what's marked as. This one says true allegations 1 through 8. I'm going to take that out. So that's not what happens. I don't know whoever came up with this idea, but there's no way this physically works with the human anatomy. All of you can't put your finger on both of these and keep it long because it just it gives out.
Maybe you should figure out how to control it. And these are upgrades, Your Honor, technological upgrades.
Better than ever.
That you asked for it to happen.
I just want one that works. That's something.
Or, you know, what the buttons. Right here.
At least they've managed to get them to load a bit faster than when they first switched.
You know what, on that, well, we're gonna have to take first of all, the pen doesn't stretch to the top of the page. And for the beginning, I know we're gonna have to cut that, but I mean, that's just a design defect. I mean, you would think in the manufacturer would have caught that. Well, again, the agreement is whatever. See, and there's smudges on every page that we have to deal with. I mean, people make, when you hit it, there's a smudge up at the top here that is circling a word that then makes it emphasize. Whatever sentence, okay, this sentence that is agreed upon is that you would be serving 18 months, sentenced to 18 months in the state jail. Is that true?
That's right.
And if I follow that, you have the right of appeal, you understand? That's right. I show you what's marked there on that page. Did you sign that? Understand it, discuss it with your attorney, or the contents true and correct?
That's right.
States exhibit 1 is tendered into evidence. Without objection with me. Among other things, this states you are waiving also any right of appeal if I follow this agreement, which I am going to. If nothing further, I'm going to find, well, you have, Mr. Castillo, you have pleaded true to allegation 2 of this motion to revoke unadjudicated probation voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily to the state jail felony of illegal possession of a controlled substance. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your plea of truth. State's Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. Now that your deferred or unadjudicated probation is hereby revoked, I hereby find you guilty beyond a reasonable doubt of that underlying state jail felony. I'm following this agreement. You are hereby sentenced to confinement in state jail for 18 months. You'll be given credit, of course, for all time you have served in relation to this case. Do you understand what is said to that? That is something. Sage Rolo.
I did.
Did you get that?
Yeah, she actually got all about that too. There it is.
Yes.
There's some. They put her down because most people,
Okay, y'all are gonna have to help me with the underlying stories on this. 18-28781 is called Sage Marie Rodall. Is that you?
Yes, sir.
You're present here with Mr. Kimbler, your attorney and the state's attorney. There's a motion to revoke unadjudicated probation that was filed over 3 years ago in 2022, which states that you were placed on 5 years deferred or unadjudicated probation on May 21st, 2018 for unauthorized use of a motor vehicle. And it begs the question, how can you be placed on deferred or unadjudicated probation for 5 years when here you are in a jumpsuit and this occurred 6.5 years ago? And this motion was filed in September. Is this the first time you've come up for this? Where have you been? Were you a absconder? Had she absconded?
Yes, sir.
Oh, okay. Because y'all aren't saying anything. I'm just doing the math. Well, that's never stopped you before.
Well, based upon his motion, Judge, they don't want to make any comments on that regard.
Well, I could, if the board wants to entertain the motion, I could.
Well, do I? It's up for you to assert.
Well, I'm presenting it to the court. Yes.
There's a motion to quash the motion to revoke probation. You want to assert it?
Yes, sir.
Go ahead.
For presented.
Go ahead.
I'm at question, Mr. Morgan.
Okay. What did you want to, hold on. Raise your right hand, sir. Do you swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yeah, proceed.
Yes.
Will you identify yourself for the record?
Oh, Ronald Marks, Jefferson County Probation.
And you're the probation officer for the defendant, Sage Rodall?
I was supervising officer from January of 2020 to May of 2020.
When was the warrant issued on the MTRP that was filed?
Under the administrative hearing, recommended motion was solved in August of 2022. I believe the warrant came up later that month.
The efforts were made to your knowledge to execute the warrant at her last known residence.
We had due diligence attempts on her case. I didn't do home visits because of the fact there was an active warrant against our policy to do home visits. I did telephone contact, I notes and letters. I did also did through our system corrections software solutions or CSS, as we call it, in text messages. And I did computer checks.
Do you know what efforts were made by the warrants? Department to serve the warrant on no residents from your department, the last known residents at the probation department maybe.
Oh, no, sir.
She don't know the efforts that were made to actually go out and arrest her at the residence that she has on file with the probation.
No, sir.
Excellent.
Anything else?
Do you know what address she was arrested at?
So the last approved residence that we had on her was, and this was stated, I know February 16th of 2022, or March 16th of 2022. She was staying at 1114 Luling Avenue, Middleton, Texas.
And that was the address in response to Mr. Kimbler's questions. That was the one where you were making all your due diligence efforts, correct?
Yes, sir.
That was the last known address she gave.
Yes.
And she was required to let you know if that address changed as a condition of her probation, correct?
Yes, sir. Yes, sir.
Did she ever notify you of any change of address?
No, sir.
So if the computer information indicates that she was arrested at some address in Beaumont on Park North, do you have any reason to believe that that was her address?
Oh, no, sir. I didn't know that address.
And so as far as the issue of any due diligence, do you feel like you did everything you could to try to get this lady to be in compliance with reporting and doing what she was supposed to as far as her probation was concerned?
Yes, sir. Our normal due diligence is every 180 days. I did due diligence usually on her every 3 to 4 months.
And you did that throughout the time frame that you were her supervision officer?
Yes, sir.
And you've testified to that today, and that's one of the reasons why you're here today instead of our current officer, right?
Yes, sir.
If I may ask, you don't know if the warrant was ever attempted to be served at the living address in their room,
By law enforcement, yes.
and you don't know when she ceased to be at that address during the last 3 years.
No, sir. The last time it was reported to me that she was there by her was on March 16th of 2022.
And you don't know when she ceased to reside within the last 3 year period, was that right?
No, sir.
And to your knowledge, no efforts were made to serve with the warrant at any time during the last 3 years. Or to execute the warrant. During the last, no efforts were made, law enforcement or anyone else that can execute a warrant, no efforts were made to execute that warrant for the last 3 years of the living in profession.
I object to the wording of that question. This officer is not responsible for executing warrants.
Do you know the answer to the question?
I didn't say.
I'm sorry. Do you know the answer to the question?
No, sir.
Okay, he doesn't. Okay.
You can't testify to that.
No, sir.
Okay.
Anything else?
No further about their motion, Judge.
Anything else from the defense?
No, Your Honor. I would just move, I think I'm more familiar with the statutory authority that I'm relying on based upon that and states the state of the evidence as far as the execution of big diligence and executing warrant would be the prosecutor.
Anything else?
That's it.
Your motion is denied. It is not proven by Congress of the evidence of greater. And that's your burden. And what are we going to do today?
Well,
let's move forward with the hearing. I mean, this has only been filed years ago. Raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Statement called Ronald Barksdale.
Okay, hold on.
Sorry.
In summary, this motion alleges that on May 21st, 2018, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of unauthorized use of a motor vehicle. Is all of that true?
Yes, sir.
Okay. And do you understand you've been charged with 4 violations of probation?
No, sir.
You didn't know that? Your attorney didn't tell you about that?
Wait, what? I'm
So you
sorry.
get four violations. The motion states, number one, you failed to report to the Jefferson County Probation Office on or about December 3rd, 2021, May 31st, 22, June 28th, 22, in violation of condition 4 of your probation order, which states you must report responsibly and regularly. Is that allegation true or untrue?
Really?
It's true? You failed to report? Okay. Number 2 states you provided a urine sample on or about January 26, 2022, which showed the presence of tetrahydrocannabinol, marijuana, in your system, which was in violation of condition 10 of your probation order, which states do not use or possess any drug. Is that true?
Yes.
3 states that you failed to provide verification of performing community service hours as required in violation of condition 18 of your probation order. Is that true or untrue?
Not true.
I do a lot of my community service
Okay,
hours.
that's untrue. And then 4, you failed to pay court assessed fees as directed as of August 2nd, 2022. You were in arrears $7,347 in payments, which, consisted of the most important thing for this court, restitution of $4,600 is the bulk of that. But there's also attorney's fees, supervision fees, Crime Stoppers fees, court costs. But the bulk of that is restitution, which is always very important because the victim, when a case is resolved this way by pleas of guilty, the victim needs to get repaid. That's what, how much was paid back?
Oh, Your Honor, her balance, no, there's nothing paid for restitution.
Nothing?
No, sir.
$0?
Yes, ma'am.
Is that, okay. Is all of that true?
I know I was behind,
All right. So are you pleading true then to allegations 1 and 2 of this motion to revoke probation voluntarily, and because those are true as they are alleged?
Yes.
You understand that a voluntary and knowingly made plea of true to 1 or more violations of probation, that is enough to grant the motion to revoke probation, and in this case, your probation could be revoked. You could then be found guilty based upon your original plea hearing that we placed you on deferred or unadjudicated probation for. You can now be found guilty and sentenced up to the full range for this state jail felony, which is no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true to allegation 1 and 2 in this motion? You're looking at him. This is your decision. You can always get advice from him. Are you pleading true voluntarily, knowingly, intelligently, and because those are true?
What is making you plead true?
I'm sorry, can I be explained what the question?
Okay, no, we'll just have a hearing on it. I mean,
You understand
you pleaded true. You understood that. And I'm just asking you, are you reaffirming that?
Yes.
You keep looking at him.
I'm sorry, I'm very nervous.
She's kind of.
I'm very nervous, I'm sorry.
You know, there was a way to avoid all this. You shouldn't have run off.
I'm very sorry.
And fled.
I did not have, I did not
The
have.
courage to come forth.
It was that, and then it was also, I did not have a good support system. I was alone.
How old are you?
I just turned 34 on Tuesday.
Wait. You've been an adult half of your life.
I've been on the tail end of life.
You've been an adult and mature half of your life.
Yes, sir.
But you're saying during this adulthood, you're not being responsible, or someone else is supposed to be responsible for you.
That's not going.
Okay, so are you accepting responsibility for your actions and decisions as an adult?
Yes, sir.
Allegations 1 and 2, are they true as alleged? You plead true.
Your Honor, she said there was rough. I haven't looked and
you know,
elicit that from them.
I know.
Not offer as an excuse.
God bless her.
And I would.
We all have our ups and downs, but we have 93% of our probationers are successful. 93, 13 out of 14. And we hate it. And we're so proud of that. We want 100%. That's why we don't want a failure like with your situation. We don't want it. We want to be able to proudly boast 100%. No one in the country's got that. And I don't know who has 93%. The average is 75%. But it's not probation's fault. They're very active and they have great pride in success. And we do, the federalists do too. That's why I hate to lose one of the sheep from the herd. Metaphorically speaking. All right, go ahead. One or the other. Either of you.
Well, I would just ask Mr. Barksdale if he would object to continue supervising if the court were to see fit to continue with the probation department's opinion.
How long has she been in absconding?
3 years.
Technically 4 years.
After all of that time, were you arrested? What happened?
Sorry.
How did you go to custody?
How did you get in custody?
They came and picked me up.
They came and got you.
My friend, yeah.
Yeah, okay. You didn't turn yourself in after 3 years.
No, sir.
What do you have to say for yourself?
You know, I'm not a bad person and I'm not a criminal. I'm a stay
Wait,
at
hold
home
on.
mom.
Hold on. We are judged by the actions, not what we talk about. The choices we make or what proves our character. Have you made good choices or bad choices?
Make bad choices.
You can fix those. We all make bad choices from time to time. But ma'am, being an absconder, you were able to live with this for years, knowing any moment someone was going to come up, knock on the door and go, you are arrested. Did you have a family at home and two? You have children?
2 small children, and that's why
You didn't think that was going to ultimately collapse on you?
I knew it was going to, and I needed to get a support system in
It was
place.
3 years long
There-
enough for you to worry about it?
Their father finally graduated and he got a process operating degree, and he's able to financially support them and me in my situation now.
Well, thank you for working on your terms, but you had committed a crime. You were under court's order, and 5,000 people have to follow the rules. They don't say, I'm not going to follow the rules. I'm going to wait until I decide it's time for me to do it.
Yes, sir.
That's like the tail wagging the dog. It's not the way it works naturally.
It was a bad decision.
But every day you were committing a crime for 3 years, and your children right there. I got grandchildren now. I can't imagine putting my family in harm's way. This is easy enough to fix back then. It's difficult when we have to go find you after years and get you. Okay.
She was also a victim and domestic abuse, not like the person she's with now early on. They said a case that was filed with the district attorney's office where she was a victim of a domestic assault, family violence. I think there's me, just my personal observation. Again, I'm not an expert, but there's some PTSD issues from that. She's obviously I think she has some.
What do you want me to see on that? Is substance abuse history?
2 things, Judge, the mental health history and the substance abuse.
What do you want to say about it?
Well, just that it's there for whatever consideration for it.
Judge, all that may be true, but the reality is she's tied our hands on this thing. She had a great opportunity back in 2022. She had an administrative hearing that was 6 months before we filed a motion to revoke probation. And the determination was she was failing. She needed some help. We agreed to put her in ISF. She signed some items to go through both of those tracks to try to address the drug issues, which is why I was highlighting that for the court. And then she was advised of all that on March 28th. And then after that, she just disappeared. She just disappeared. She decided she didn't want to do it for whatever reason. And she never contacted.
Let him speak. You're going to have a chance to speak. Don't interrupt him, please. Thank you. Go ahead, sir.
The specific deal. She agrees to it. She reported on an office visit on March 28th. And then the words of the probation
March 28th
of 2022. Then the rest of our administrative hearing said defendant never reported back and her whereabouts are unknown at this time. I'm translating that as she disappeared, which goes right to what Your Honor's been saying. For every day after that, she knew what was happening. She knew it. She's known for now just shy of 48 months. I don't agree to place her back on probation. I think it's a sad situation, but it's one she generated herself.
Okay. Go ahead, defense. What do you want to say?
I think what Mr. Ham said is accurate, Your Honor, but it's what her own self is and how she's able to do things. That's the objective. There's the subjective to the person, the employee, and her own individual circumstances. I'm not trying to excuse it, but people are people. People have weaknesses. People suffer from all sorts of problems and things. And I guess not an excuse. It's just an observation. Struggle. Obviously, should have been listed a different way, but you're not dealing with a particularly strong individual or family. So that's not an excuse. It's just the way it is. So whatever the court does.
Well, it's
your,
I'm in a
your
spot.
determination.
The court's in a bad spot. The defense is in the bad spot, but the court has little position to do anything.
I don't think she
but
extended
severe in it.
Extended or
Not only absconding, we have a victim here that wasn't paid a dime back. for the loss, not a dime.
If I might, it's an unauthorized use, it's unclear if he lost, it's not a theft, so I don't
It was
know.
ordered to pay restitution of $4,600. Must have been probably damage to the car.
It wasn't.
I don't know.
I wasn't
I
sure.
mean, that's only common sense, right?
Wasn't a theft.
Is that what it is?
It was. She was involved in a wreck that caused that much damage to the other individual.
Not a dime was paid back to the poor victim. And then you absconded. But 5,000 probationers, keep an eye on what this court does, on how things are going to work. And they're going to act the way the court rules. And you made promises you did not keep, not a one. Go ahead. You have a right to say something.
So whenever I had agreed to probation in the first place, I was under the impression that I was going to have a support system which consisted of my mom and my stepdad. I was unaware that.
So it's somebody else's fault?
No, so
That's what it sounds like you're trying to say.
On my feet, like, because they asked me.
How old were you when you were here?
I think I was 24.
Okay. You've been an adult for 6 years,
I
a quarter of your life.
I just want to add that I have the means now. I am
On your terms.
I have, well, no, sir.
Yes, this is what
Just
you're telling.
like working, like financially, I have the means now.
Okay, how long have you been doing that? How long have you been financially?
I just got on my feet like a few months ago after getting my children's father.
The moment you did, why didn't you report?
I was actually going to.
Oh, you were going to that day? Or
No,
you
sir.
were,
No, sir.
you know how hard that is to believe.
I was going to.
Well, on your terms, though. See, you were going to, like, the moment you saw an opportunity to do the right thing, you should have done it. But you did not. We had to find you again. This is a case where it's a terrible set of circumstances which you placed yourself in and the others who depend upon you. And this court has very little room on this one because everything surrounds reporting. If you can't do anything else, you got to report or else you're not on probation. You decided you were going to be in control of the probation, which is the tail wagging the dog. It doesn't work that way. It can't work. Then it's not going to work on this court's watch. We don't need probation officers. We got you. But how did you do? You didn't follow any of the terms of probation. None of it. Anyway, what else? Anything else?
All
right. If there's nothing further to add, I'm going to find that there is sufficient evidence. I'm going to find that there is sufficient evidence to grant this motion to revoke unadjudicated probation in cause number 18-28781 by a preponderance of the evidence or greater. As the defendant has pleaded true, voluntarily, knowingly, intelligently to allegations 1 and 2 of the motion to revoke probation. That is failing to report for years and providing urine sample, committing a crime by having drugs in her system. That's another. I noticed you didn't ever discuss that one about how the drugs fell into your system.
So
You want her to, Your Honor?
If she wants to tell me.
I'm not like an addict or anything like that. I mean,
But you're going to be forthright with me.
I guess, sir, yes.
Where'd you buy the drugs from? Where'd you get the drugs from?
My sister.
Huh?
I got them.
From whom?
My sister.
What's her name?
My sister.
What's her name?
Name Samantha was.
Where does she live?
I honestly couldn't tell
You honestly can't tell me where your sister lives?
I haven't talked
Where's
to
the
them
last
last
place?
year, so somewhere in church on I don't know the road name.
You don't even know anything about your sister, where she lives, but you get the drugs from her.
This was over it was about 4 or 5 years ago, and I haven't spoken to her. We've fallen out, and I have not spoken to her in over a year. The last place I knew she lived was in that neighborhood behind 365.
You need them?
Anything else?
I have been clean and sober since all of that.
Is that your word?
It is.
You
yes,
mean
sir.
just like you promised to report and follow all the conditions of probation under oath that you signed on? That word that you gave me, is this the same kind of oath?
It's
Is the same kind of honesty you used now that you're using it in? Using now that you
being
did then?
totally, completely honest, sir. I made a bad decision.
Oh, you weren't honest with me when you swore to follow all the terms and conditions of probation in the first place?
I was.
You're hammering into the.
I have a lot of mental health problems, and I am finally able to actually get some real, besides MHMR, because they were not helpful to me. They didn't have me on the right medications. I couldn't receive actual
It's
therapy.
somebody else's fault, all this happened.
No, sir.
That's what you're saying. When are you going to accept responsibility for anything?
No, I'm telling you, sir, this is my fault.
Okay.
Yes, sir.
Well,
I
stand up.
want to
All right.
take full responsibility because I have learned my lesson.
When did that happen? When did you learn your lesson?
Whenever I got in trouble, and it was my last.
When was that?
It was the last time I reported, and I knew that I was making bad decisions.
When was that?
Because I couldn't.
How long ago?
It's not good. I'm sorry.
Years ago.
It was a couple years ago. Yes, sir.
What?
I'm
You said, I don't understand. You're speaking out of both of them. So you understood and accepted responsibility and realized everything you were doing was incorrect and wrong, and you were committed to doing the right thing. So quite naturally, you responded for 2 more years.
I was found my own. And I could not, I was so scared that I don't know what was going to happen with my children. And I got to.
Well, let me just say, the greatest gift you can give to your children is being a role model and setting a good example. So you were a fugitive for 2 years around your children. If nothing further, this is getting worse. It's a terrible story. It's terrible. You're supposed to set a role model, be a role model and example. You were sitting there with it. You know how your children, how adverse that can be for your children. I mean, you needed to fess up to this the first moment you were placed on probation. You did. So the whole family suffers. The little kids. I've got children and grandchildren. I can't even imagine making choices like your choices, because I think of my children and I see them, how it would affect them. But nonetheless, you were committing a crime every day in the household, every moment after you violated probation. All right. We've beaten this one up. There's sufficient evidence supporting this motion to revoke probation. Been granted by a preponderance of the evidence or granted. His allegations 1 and 2 have been proven true by a preponderance of the evidence or greater, as the defendant has pleaded true, voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke unadjudicated probation that was filed years ago. And it is granted. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you had pleaded guilty voluntarily. You were met. Just so I understand and I appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty in your plea hearing to original plea hearing to now find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of the state jail fallacy of unauthorized use of a motor vehicle. And you were hereby sentenced to confinement in the state jail for 2 years. Plus, the judgment shall reflect you owe restitution of the full amount that you never paid a dime on to the victim in this case, $4,600. That will be in the judgment as well. You will be given credit for all time you have served in accordance with this case. And I think you have 152 days credit.
Will the court consider suspending it?
No.
You have a chance to pay the institution.
I will send a message that you can abscond for years. And then when you decide to come back, you didn't decide. When you get caught, not on your own, it would have been different probably if she would have done the right thing that she said she was so the guilty feeling around her children for years, but she didn't make the step. And I am opening a door. Let me just say, we start opening the door. I believe in fairness in this court. And we start opening the door for that. Everybody's going to say the same thing. Okay, I don't even, when I get caught, I don't even need to come forward and do the right thing. If I get caught, I will use the sage Rodall rule, because what's fair is fair. When I get caught, if I get caught, then we're going to play like I didn't accept responsibility. And that's okay. That's not going to be working against me. But this is the most important concept of all probation is you have to report, you have to be on probation. If you can't follow some of the terms, that's what the probation office is there to guide you and help you. You can't walk off the job from the beginning and then expect that we're just going to pick it up where we left off now and I'll follow the rules. It has its responsibilities. It also has its example for others. If you scamper off, I'm going to give you credit if you finally feel bad enough that you turn yourself in. But this is years, almost 4 years. You never felt bad enough. We had to find you and catch you here. So that's the court's ruling. I'm going to be fair. I'm going to be fair and others. But it shows the importance of you committed, you made promises, you didn't keep from the outset. And this is called accepting responsibility, something you have failed to do for years as a person and as an adult. And I'm the guy that has to put you into the responsible mode, but you're going to be held responsible. I feel sorry for the whole group, but it's your fault, your choices. And people who abscond, and when they finally get caught, we're not going to pick up like all this forgiveness. You've been thinking about it. This hadn't bothered you enough for years. That's the rulings of the court.
If she is a convicted felon, there would be a difference. She would be sanctioned since she's lost her first status. But I understand.
Court's rulings are what they are.
All right.
Thank you. Okay, I have Doracia Williams.
That's right. That's a hearing, Your Honor.
Reagan McCain. What are we going to pay on Reagan McCain? You're doing today, please?
The case is going to be a plea on both cases. You all
You call then. Let's see, 23 CR 1517 and 1520, the state of Texas versus Reagan McCain, that is you?
Yes, sir.
You're here with Mr. Paget, your attorney, and the state's attorney. Does the defendant waive formal readings of these indictments and these arraignments? Can we proceed in summary?
She does, and yes, Your Honor, we can.
Okay. In summary, 1517 indictment alleges that on or about June 7th, 2023 in Jefferson County, Texas, you committed the third-degree felony of hindering apprehension or prosecution of a known felon. See, with the intent to hinder the arrest, prosecution, conviction, or punishment of Jamal McCain for the offense of murder, you provided aid in providing Mr. McCain with the means of avoiding arrest, namely providing transport and food and necessities to Jamal McCain against the peace and dignity of the state, signed by the foreign. This is a third-degree felony, which means if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range for this crime?
Yes, sir.
An agreement's been reached, you be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. This is going to run concurrently with 1520 a state jail felony of theft that we're going to be dealing with in a minute. Is this your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. You understand?
Yes,
How
sir.
do you plead to this charge? Guilty or not guilty?
Guilty.
You pleading guilty voluntarily and because you are guilty. That was a question.
Yes, sir.
Okay. Okay. What do I do? I don't see the same bars as I used to see. Where do I hit to process it? I don't know. I see it used to be this thing, but it's not that anymore. Where do I hit to move it to you? Where'd you?
It's up
oh,
there. That thing was at the bottom. I just needed to click off of that for this to pop up back up.
And we're gonna have to take this off after all of this. This needs to be freestanding because it pulls back. Something else. Supposed to be newer and better, but it's never is.
My experience over the past 30 years is nothing new. It's just my experience.
All right, in 1520, in summary, this indictment alleges that on or about April 25th, 2023 in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty, placed in deferred or unadjudicated probation, which can be up to 5 years in length, among other things. Restitution is owed. Is this right?
What do you?
Is it restitution is what this is?
Yes,
Just check, but there's nothing there. It just says $2,883. I guess that's restitution.
It is restitution.
To
You're
whom?
right. They're
To the-
ULTA, ULTA. ULTA. There are 3 or 4 defendants, Your Honor, but that's why I checked the.
Oh, it's what? Yeah. What does that stand for?
It's
Is it?
It's
U
the name
period,
of a, no, sir.
Ulta Corporation?
It's a
It's a store in the mall that sells like makeup and fragrances.
Okay, how do I just says Ulta.
That's the name of the store.
And that's how it shows up on the, sure, it's ULTA.
Okay, is that going to be good enough? Just Ulta?
Yes, sir.
I assure you it will be good enough. Your Honor.
We all know what that is.
3 daughters and a wife.
Yeah.
I assure you.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Y'all need to sign, each of you. And you watch the pad, watch that pen. It's tricky. It wants to pull back on you.
You've already signed. No, okay. Prosecutor does, but I've already signed. Your Honor.
What's the other? Is the defendant needs to sign it?
No, it looks
There were
like
2 places.
You, Judge.
just you and the prosecutor.
Okay.
I mean,
I'm
I'll
sure-
sign for you.
Did you see
but
State's
I have to get
Exhibit
my
1?
permission.
Yes, sir.
Did you sign that? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objections to stage 1. Your Honor.
Without objections, it's noted.
Like
In each
it.
of these cases, State's Exhibit 1 all states that you are mentally competent to enter your guilty pleas in each case, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You were guilty of the crimes charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. Do you understand?
Yes, sir.
All of that's true.
Yes, sir.
State's Exhibit 1 in each case made it part of the record for all purposes. Pre-sentence reports are waived.
Yes, Your Honor.
Okay, I'm going to follow the agreements in each of these cases. And I'm going to find in each case, ma'am, you have pleaded guilty, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitting in each of these cases to find you guilty beyond a reasonable doubt.
I'm thinking maybe leaving us. Yeah. That's how we handle it.
Even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation in each case. You will be placed on 10 years deferred or unadjudicated probation in 1517 and for 5 years in 1520, the state jail felony, and those will run concurrently. Restitution will be owed in the theft case to Ota in the amount we discussed, which is on the in the disposition papers that you signed. And there is no fine, I believe, in 15.
That's correct. On either case.
In either case. And make sure you follow the terms and conditions of probation, which will be reviewed with you by the probation officer in a moment. If you fail to satisfactorily complete probation and violate in 1517, for instance, that's a third-degree felony, your probation could be revoked. You could be found guilty and sentenced up to 10 years in prison in that case. And in the state jail felony 1520, your probation could be revoked. You could be found guilty and sentenced up to 2 years in that case. You understand? Yes. This is the probation office. Thank you. Thank you.
Thank you, Your Honor.
Yes, sir. Thank you. Just sit down. Take care. Okay. See you. Yeah, you're right about this. We're going to clip this, we're going to pull this pin off, the stylus off of this thing. It just, yeah, it's not working. That's a design defect if I ever saw one.
Let me go get my scissors.
Well, we can do it later. Yeah. Okay, I have. Shannon Ardwan. Well, hold on. Brent, did you have something else? Yes. Go on. Come on out.
Just Mr. Ardwan is in the jury room viewing more videos. He's representing himself. This was just for him to use some more media.
Mr. Champagne, it's my flat, Judge.
Ardwan.
What about Gregory Renthal? Yeah, I know, but it's not yours anymore. That was yours.
That was an add-on.
I have a Renthal, but he wasn't set to the table. Somebody else? Okay.
Who is it?
Markham Champagne.
Page 4.
With the rest of the.
No, I don't have a Champagne on 4.
It should be 2 cases.
Williams, Castillo, and Hadnot.
3, maybe.
That's page 3.
Sometimes their dockets print differently than ours.
Hold on.
It's on page 4. It was.
Champagne.
Yes, sir.
2 cases.
Yes, sir. My mistake.
That's it.
You moved up on the rules.
So what are we doing today?
The plea, Judge. On both.
Yeah, cut it.
Absolutely.
Just in case you need it.
Right, some scissors.
They didn't take my knife to the judge.
Be careful with that thing. No cutting any wires. Okay, you can cut that wire.
Good.
So why can't other styluses work on it? You don't know?
Because then they couldn't charge you for.
Well, no, you get charged with the pad.
I know, that's why, about the same reason my.
That's a special pad. I mean, that's their design. That's their design.
I didn't ask a whole lot of questions when they dropped it off yesterday.
Okay. Two cases I'll call here, 23 CR 705 and 706. You are Markham Joseph Champagne.
Yes, sir.
Present with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive formal readings of these indictments and arraignments here? Can we proceed in summary?
Yes, Judge.
Looks like they allege the same thing, the same type of crime. In 705 and 706, can we take these up together?
Yes, sir.
In summary, so these indictments allege that on or about October 26, 2022 for 705 and on or about October 27th, the next day, 2022 for 706, it is alleged that in Jefferson County, Texas, you committed the state jail felonies of forgery of financial instruments. That is, with the intent to defraud or harm another, you intentionally or knowingly made or completed writings so that it purported to be the act of the complainant victim who did not authorize the act, and said writing were checks in the amount of $4,900 in 705 and $4,000 in 706. And it looks like it was on the complainant's checks and purportedly signed by the complainant when this, and it says for bill and bills in the check memo portion. And is this what we're talking about? So you forged those checks?
Yes, sir.
And did you get the money for them? Did you get money?
Yeah, I got it.
$8,900?
It was.
What did you get? $8,900?
Yes.
Okay. What did you do with that?
Um,
Is it still around? Can you
No.
get the money?
It had-
It has
The
been paid back,
restitution's
Judge.
been paid back?
He is clear and free.
Hey. Here you go. Oh. You're gonna have to help me learn how to do all of that, because
No, I'm gonna have to figure it out too.
now it's blank.
Oh,
What'd you do?
I just hit that icon at the bottom.
Where? Which icon? There's only
Right
that.
there, the one with the blue line under it.
All right.
I'll ask you.
Us payments don't get them.
Mm-mm.
All right, an agreement's been reached here in 705 that the defendant would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years to run concurrently with the proceeding case, which is 705. I'm sorry, 706. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal.
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That
Yes.
you're on your own free will and because you are guilty? Yes.
Yes, sir.
That one side, go to 706. In summary, we talked about that on or about October 27, 2022. You committed the state jail felony of forgery in that case. And similarly to the preceding case, this is a state jail felony, which carries with it no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can be assessed. Do you understand the punishment range in both of these cases?
Yes, sir.
And here, as in before, as the previous one, you will be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years.
Yes, sir.
To run concurrently with each other. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this case, guilty or not guilty?
Guilty, sir.
Are you pleading guilty in each of these cases voluntarily, knowingly, intelligently, and because you are indeed guilty of these crimes?
Yes, sir.
I'm going to show you in each of these cases what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You were given the refined charge and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of the witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 in each case made it part of the record for all purposes. Pre-sentence reports away.
Yes, Judge.
I'm going to follow these agreements. If nothing else to add, then.
Just one thing to add, Judge, just want to make sure it's clear, and I already talked with probation.
Yeah.
Mr. Champagne has severe medical restrictions, and he's going to bring medical documentation to support his inability to do community service, but he does have medical documentation to prove that he has lung issues, as the court can visibly see. Just so
I can visibly see, but I don't know what they are. They appear to be something. I know anybody can stick an oxygen hose into their nose, but how long? What's the problem you have?
I have COPD, emphysema, and I have been recently diagnosed with asbestosis.
Okay. And how long have you had those conditions?
Since November of 24, I was diagnosed. I have all the medical records.
And he'll provide him with probation, Judge, so that he can waive the community service. Again, I was just talking to probation, give him a heads up.
My lungs are turning into stone, Judge, basically what it amounts to.
Where did you, was it from occupation?
Yes, sir.
What are you doing about that?
Every lawyer that I've talked to has
denied,
pretty much pushed me off until I can get further documentation from the doctors.
Doesn't sound like the lawyers I'm familiar with.
The problem now is the bond is the only thing that's available. You can't really sue the asbestos people anymore. They got the government to cover them.
It's been a hard task. And I'm not finished fighting.
Well, at Provost Humphrey, that's what we did regularly. Help people. When I worked, that was a long time. They did a good job.
They can put their heads up, Judge.
Okay, if nothing further, I'm going to find you, in each of these cases, you have pleaded guilty voluntarily, knowingly, intelligently. There is sufficient evidence supporting your guilty plea in each case from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. I'm following these agreements. You're hereby sentenced to confinement in the state jail for 2 years in each case. That will be suspended. You are placed on regular probation for 5 years. Among other conditions of probation, you must complete a theft class, and there will be conditions of probation which are normally customary for these type of offenses. Please see this probation officer and make sure you understand them fully and follow them. If you fail, your probation could be revoked. You could be found guilty. I'm sorry. Your probation could be revoked, and you can be sentenced up to 2 years state jail in each case. So follow them and well. Thank you, sir. Good luck. What are we doing on the Quan had not? Anybody? The Quan. Hey, you know what? I like it. You know what? I'm hitting this thing here. This little blue thing, and it's not doing anything. Look, see what I'm doing. Oh.
I'll take some things too.
And now we call cause number 24, CR 2253, the state of Texas versus Daquan Hadnot. Daquan Hadnot. And there was an administrative hearing memo sent to the court where it alleged the defendant had failed to maintain employment while on probation, failed to perform community service, refused to submit to alcohol drug screenings, failed to comply with the rules and regulations of the probation office, and we had transferred or allowed the defendant to courtesy report in Hardin County, failed to report to Hardin County for scheduled appointments, failed to report to Jefferson County by mail, had reported for his administrative hearing, and refused to submit to drug screens, among other things. Anyway, the recommendation had been a 10-day jail sanction. The court, for which the defendant did not agree to the recommendation. The court did not approve and sign this administrative hearing memo because the court wanted the defendant to be here in person so the court could examine him for his his conduct problem while on probation. He was ordered to be here today. He has failed to appear, and this motion to revoke probation shall be ordered to be filed in this case, alleging any and all grounds of violations. Yeah, you can. But in this case, Daquan had not. There's no answer here in the courtroom, and the bailiff can call into the hall, please, for Daquan had not. And this is cause number 24 CR 2253. The defendant is on probation for the state jail felony of theft of a firearm. And 5 years deferred or unadjudicated probation. And there's no response to that name being called into the hall as well as in the courtroom. The court's orders to move forward and file a motion to revoke probation in this case. And we will deal with it when he is caught and comes forward. I guess, when was the last time he had reported?
So I talked to him, he got removed from Hardin County, so he hasn't been seen in person since our admin hearing.
Which was?
It was on, I'm sorry. It is 1/6 of 26.
I'm sorry?
1/6 of 26.
Oh, earlier this month.
Yes, sir. And I just spoke with him on the 20th to let him know that we were going to go to judicial review and where he should come and then I think we will.
Okay. Well, that's. He's gonna have to be held responsible like everyone else. If you can't do anything else, you have to report or else you're not on probation. Okay, thank you.
Thank you.
All right, I have Dorisha Williams.
That's it.
Okay,
State truth.
all right, let's move forward on that one, please. And there is no agreement, right?
Right now, there's.
Okay, that's okay. What hearings are all about? Come on up, everybody. Brother here, we'll do is this for the time, the moment here. 25 CR 425 and 25 CR 1835 are both called the state of Texas versus, is it Dorisha?
Yes, sir.
Dorisha Marquise Williams. And that is you.
Yes.
Present with Wright Kimler, your attorney, and the state's attorney. Does the defendant waive a formal reading of these motions to revoke? Well, there's a motion to revoke unadjudicated probation in 425 and what looks like a new indictment in 1838, correct?
That's correct, you know.
All right, we're going to have a hearing on the motion to revoke probation today, right? Let's just deal with that one then. In 25 CR 425, a motion to revoke unadjudicated probation has been filed as of December 12th, 2025. Are you familiar with this, ma'am?
Yes.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. In summary, can we take this by summary?
Okay.
In summary, this motion states that on July 9th, 2025, last year, that you were placed on 10 years deferred or unadjudicated probation for the third degree felony of evading arrest or detention with a motor vehicle. Is all of that true and correct?
Yes, sir.
Okay. Allegation 1 states you committed the offense of assault on a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of your deferred adjudication order, which looks like it is what is represented in this new indictment filed as of December 3rd, 2025, alleging the second degree felony of assault on a peace officer. That allegation, is that true or untrue?
Yes, sir.
Sir, ma'am?
True.
Is it you pleading true to assault on a public servant?
No.
Untrue.
No, it's
Untrue.
No.
Okay, come on. Yeah, follow what I'm doing here. That's untrue, right? Okay, that's what will be entered into the record. Number 2, you committed the offense of fleeing from a police officer on or about October 19th, must be out of the same event, 2025 in Jefferson County, Texas. And that as well as a violation of condition 1 of your deferred or unadjudicated probation order, which is do not commit a crime. Is that true or untrue? 3, you failed to provide verification performing community service hours as required by the probation order. Is that true or untrue?
That's untrue.
And finally, you failed to pay court assessed fees as directed as of December 3rd, 2025. You were in arrears $425 in payments of fees, and then you are required to pay fine, post-sentence investigation fee, Crime Stoppers fees, supervision fees, your different sets of fees that all probationers have in some form or in amount have to be subject to. And is that true or untrue?
It's true.
Or were you able to pay?
I wasn't.
Did you pay as much as you could pay?
I wasn't able to pay because I was in and out of job.
Okay, you were unable to pay.
Right.
Okay, so untrue will be entered in for your behalf. Okay, y'all have a seat and let's move forward.
Yes, open.
Oh, okay. Thank you.
Call your first witness.
Officer Locke.
There was no agreement on this, right? Okay. Come forward, sir. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing